this hearing of the Senate Economics References Committee for the inquiry into the unlawful underpayment of employees' remuneration. The Senate referred this inquiry to the committee on the 13th of November 2019. The reporting date has been extended several times. On 10th of February 2022, the Senate granted the committee a further extension to report by the 30th of March 2022. Submissions closed on the 6th of March 2020, with the committee receiving 130 submissions. These documents are available on the committee's website. As this is a public hearing, a Hansard transcript of the proceedings is being made. However, the committee may determine or agree to a request to have evidence heard in camera. Information on procedural rules governing public hearings and claims of public interest immunity has been provided to witnesses and is available from the Secretariat. Any witness called to answer a question for the first time should please state their full name and the capacity in which they appear. Witnesses should speak clearly to assist Hansard to record proceedings. To assist with the recording of this hearing, please ensure your microphone is set to mute when you are not speaking. I remind media representatives listening to follow the media guidelines and any instructions of the committee secretariat. I ask everyone to ensure they have switched off or turned their mobile phones to silent. I would like to advise witnesses that answers to any questions on notice should be sent to the Secretariat by 5:30 Wednesday, 9th of March 2022. And I now welcome representatives from Industry Super Australia. Thank you for appearing before the committee today. I invite you to make a brief opening statement should you wish to do so. But right now, for the Hansard record, could you please state your name and the capacity in which you appear?
Certainly, Chair. My name's Matt Linden. I'm the Deputy Chief Executive of Industry Super Australia.
Thank you, Mr. Linden.
And good morning, James Gunn, Senior Manager of Public Affairs and Research with ISA.
Thank you, Mr. Gunn. Do you have an opening statement?
We do, thanks, Chair. And we'd like to thank members of the committee for the invitation to appear into this important inquiry. ISA manages collective programs on behalf of 13 industry super funds with the objective of maximising the retirement savings of around 5 million members they represent. Superannuation is, of course, part of a person's remuneration that's preserved for retirement. But because super is required to be paid less frequently than their wages, and workers generally have lower engagement with their super, the non-payment or underpayment of super entitlements by employers is a chronic and persistent issue, which we estimate is costing workers around $5 billion per year, according to our latest analysis. For many years, ISA has been a vocal advocate for stronger policy settings that tackle the underlying causes of unpaid super and ensure workers are paid their full and proper entitlements. This is clearly in members' best financial interests, as well as, I might add, taxpayers who ultimately foot the bill if members are retiring with less money and are eligible for a higher pension as a consequence. In collaboration with our member funds, ISA contributed to the last Senate inquiry looking at the issue in 2017. Committee members would be aware of the Super Bad report, which looked at wage theft and non-compliance with the super guarantee. It made 32 recommendations, many of which to this day have yet to be actioned. Since then, we've released a new report containing detailed quantitative analysis estimating the impact of unpaid super on workers using the latest publicly available tax data. This report's been provided to the committee. In brief, our new analysis shows the problem has not materially improved. The analysis adopts a precise bottom-up approach relying on individual unit record data. The ATO uses a broad top-down approach in estimating the SG gap, and it does tend to understate the full extent of unpaid super by allowing super payments of those receiving above the legislated minimum from employers to offset other underpayments, which is encapsulated in the aggregate data. Just quickly, our analysis shows unpaid super affects around a quarter of the workforce, costing each affected employee an average of $1,700 per year. Unpaid super is more likely to affect young workers, those working in certain industries such as construction, hospitality and retail. A young person who experiences unpaid super could retire with $60,000 less in retirement savings in today's dollars. Total underpayments of super over the last 6 years have trended up in dollar terms, but there's been a small relative decline as a percentage of the SG base due to employment and wages growth. ISA has supported positive steps taken by this parliament and the government in recent years to reunite members with the money that they're owed. It's pleasing to see recently legislated was the removal of the 450 threshold. However, there's other fundamental recommendations such as mandating more frequent payment of super that remain unaddressed. ISA provided conditional support to the SG amnesty introduced in 2020, covering 25 years between 1992 and 2018. As at 30 September 2020, $538 million had been returned to members, and employers caught after the amnesty for historic underpayments have faced higher penalties. ISA recommended a carrot and stick approach where penalties were strengthened after the amnesty period concluded, but regrettably this only occurred for historical non-payments and not prospectively to act as an effective deterrent for future non-compliance. Based on ATO data, around 3/4 of Part 7 penalties are still remitted by the ATO, further reducing the impact penalties could have as an effective deterrent. It's also disappointing the ATO does not publish its enforcement actions against unscrupulous employers and call out poor practice so that enforcement activity can be seen as a deterrent. There's a couple of points which I did want to make as well, which should lead to some improvements. We've previously seen the rollout of single touch payroll to businesses of all size, and the ATO has said that this is a new weapon in its compliance activity, but that hasn't yet appeared to have materialised at scale. Employee and third party notifications to the ATO, that's when employees actually make a complaint to the ATO about not receiving their entitlements, still make up a significant proportion of unpaid super investigations by the ATO. There is still a lack of transparency around how the ATO is using single touch payroll against other ATO data to identify when underpayments are occurring, and these processes should really be automated, yet it appears they are not. However, there are some underlying problems which need to be addressed. The ATO, despite its best efforts, is handcuffed by a policy framework that's not fit for purpose. Contrary to the original system design in the original legislation introduced in 92, super is not well aligned to the payment of wages. Outdated laws permit super to be paid just quarterly, with up to 4 months elapsing between a super entitlement accruing and being on an employee's payslip and its eventual payment. The ATO has repeatedly said its job is made significantly harder because of the infrequency of super payments and its members who pay the price. In almost every case study we've looked at, employees who were underpaid super were shocked to learn even though it appeared on their payslip, it wasn't actually being paid into their accounts. The ATO likewise has lamented the challenges it faces under this framework, the promise to pay versus the actual payment. More frequent payment of super would allow the ATO to act quicker, make it easier for employees to track their payments and harder for employers to fall behind. It would improve cash flow practices and even the playing field for businesses. More frequent SG payments would help businesses by limiting the accrual of large SG liabilities that make it actually hard to meet those obligations. Businesses who do the right thing and pay their employees super entitlements in full and on time are being commercially disadvantaged by those that don't. Businesses and employer bodies have told us their members often get undercut by employers that are doing the wrong thing, and it is about time that our employers were put on a level playing field when it comes to the payment of super. Insolvency, of course, is a major cause of unpaid super. The ATO has pointed that some businesses use super entitlements to fund other liabilities and obligations at the expense of employees. This is clearly not what super is there for. Super is members earned wages and remuneration. Paying super with wages, how parliamentarians incidentally receive it, would benefit all members, as money going to accounts more often means those amounts could begin to accrue investment returns sooner. And this, in fact, would lead to financial benefits to members. We've previously estimated that average wage earners could be around $12,000 better off by retirement with more frequent payments. Quickly on the Fair Entitlements Guarantee, as recommended by the Senate in 2017, super should be included in the Fair Entitlements Guarantee. It currently is not. Again, the ATO has repeatedly called out its inability to act when an employer becomes insolvent, and that insolvency leads to a cause of unpaid super. Further, including super in the National Employment Standards would also give affected members more avenues to recover their underpayments via the Fair Work Ombudsman. ISA looks forward to working with the committee and the government to addressing this significant issue in the financial interests of fund members. Thank you again, and we're very happy to answer your questions.
Thank you very much, Mr. Lendon, for that comprehensive opening statement. I'll kick off with a few questions and then go to Senator Scarr. You talked there about the sometimes poor business practices of some employers that avoid paying super and seem to sometimes treat super as just sort of one of many debts that they may get to at some point. And you referred to the ATO's treatment of that sort of behaviour. Commissioner Jordan has previously told the Senate Economics Committee that not paying super is the pragmatic nature of a business that is making a choice to survive. What do you say to that view from the ATO?
Well, look, I really think it's quite an unacceptable practice. Employees, of course, would recognise, very quickly if in fact their wages were not being paid, but the current lag between the entitlement to a superannuation and its eventual payment gives rise to this situation where employers may improperly utilise that money for other purposes, including additional working capital for their business. And that's really quite improper and certainly something which, as the ATO has identified, is a problem. And it would be addressed if in fact the payment obligations required employers to pay more frequently. There's a real moral hazard which operates here where the law permits very lengthy periods of time before these superannuation entitlements need to be paid. And it's that gap in the law that in fact facilitates and enables this sort of conduct to occur.
Okay. Well, considering those issues about how some businesses delay or not pay super and then can find themselves in considerable trouble later on and going into liquidation, which makes it even harder to recover lost super. Can you explain to us a little bit more how an option of payday super would actually work, and whether you think it would assist business or do you think it would impose a burden on business?
Look, I think we need to go back to the original system design to understand why this came about. The original superannuation guarantee legislation introduced to the Parliament actually had monthly payment obligations for employers, but as a sort of suite of amendments which the Democrats were involved in, there were some changes which were made. So there was a 450 threshold added, and the requirement to remit moved to a quarterly requirement. Now, that was out of some concern for business and the payroll systems which existed at the time, which for many businesses were quite manual processes. We are now a long way down the track where, in fact, the technology is improved for businesses, and even small and micro businesses can get apps, and they use apps to issue invoices to their customers and also to pay wages and superannuation. With many of that and those apps and single payroll touch rolls, single payroll software, in fact, employers need to make an active decision not to pay at the same time as wages and allow those liabilities to accrue. So from a account keeping perspective and for employers, it's actually quite a simple process now, and many employers do currently pay more frequently than the quarterly obligations. Larger businesses and medium-sized enterprises, it's quite common to pay more frequently, and this, a not insignificant proportion of smaller businesses do as well, because the technology allows it. And in fact, it has often been put to me over the years when we've looked at this issue that this would be an impost to require more frequent payment. I really do struggle with those arguments, because allowing large superannuation liabilities to accrue does not aid the cash flow of a business. It in fact impairs its ability to get on top of its cash flow. So, much like the new tax system reforms in 2000, the Prime Minister at the time, John Howard, and Peter Costello made much of the new business activity statement arrangements, which required more frequent reporting and around taxation and remittance. The same principles really ought to apply to superannuation.
And you've also said in your opening statement that some businesses suffer a competitive disadvantage when they're doing the right thing, and they're competing with businesses that might have a 10% wage advantage by not paying their super. How would you see that this sort of payday super approach would, assist business to compete fairly in the market?
Well, it's sort of two-pronged. I think it changes the expectation, and in fact, the legal obligation which employers would have in relation to when they pay superannuation. So it will change, practices, which is important. The thing which so we know from the ATO's evidence that it would hasten its ability to detect underpayment or non-payment because of the payment frequency increasing. So it will assist the ATO. It will assist members to be more engaged with their superannuation. A constant struggle for them at the moment, if in fact their employer is paying against a quarterly schedule, is trying to reconcile the figures which are on their pay slips, which often are fortnightly, but maybe at other intervals as well, with these quarterly payments, which is quite an exercise if anyone has attempted to do that. There's also information that's available through MyGov as well, but there is really there is a problem with the reporting around what the obligation is. It still needs to be matched up to a payment which is might only occur 4 times a year, so it makes it quite difficult. But moving employers onto a level playing field is really quite important. As you say, those employers who are doing the right thing, meeting their legal obligations, are being undercut by employers who are not, and they get effectively a 10% payroll advantage as a consequence. So this is an issue which is not just important for members of superannuation funds, it's also important for employers, and ultimately it's important for taxpayers, because if people are not receiving their correct entitlements, they're retiring with less super in their nest egg, it's very likely they'll be eligible for higher age pension payments, which of course has a cost for taxpayers.
And on that last point, do you have any sort of estimates on the ultimate bill for the taxpayer of the $4.5 billion super gap?
We do. We did include some estimates in our report before last, which I might provide to the committee on notice.
Yep.
It is a problem which is building, however. in line with the system as successive cohorts, those imposts for taxpayers in effect are crystallised as employees are retiring. So it is a cost which is building over time. But already we can see that it's material. When we analyse the taxation data for those on the cusp of retirement, they have tens of thousands, all other things being equal in respect to their wages, gender, their age. Those who appear to not be receiving their entitlements have got tens of thousands of dollars less in their superannuation at the point of retirement.
Yeah.
And that flows through, of course, potentially to the age pension.
Just finally from me before I go to Senator Scarr, but it may be a fairly significant area of your evidence. Do you think the challenge in relation to the ATO is primarily that they don't have enough powers to enforce compliance, or that they're not using those powers effectively to enforce compliance? And then I guess related to that more generally, you have called for superannuation to be included in the National Employment Standard. Is that part of a proposal that would lead to different avenues for people to be able to enforce compliance in other jurisdictions, like the Fair Work Commission, for example? Would that be a more appropriate avenue? Yeah.
I might answer that second question first and ask my colleague James Gunn to talk about the situation with ATO's penalty regime, etc., because it's something that she's looked at very closely recently. But in relation to the National Employment Standards, our view is that it in itself is not a silver bullet. There's a series of policies which are needed to address this issue, but it would be very valuable. Most people would not be aware at the moment that an individual employee actually doesn't have any legal standing to pursue underpayment of superannuation unless it's specifically included in their employment contract or individual contract in particular terms. But in most instances, they're powerless. They need to rely on the ATO because of the way the superannuation guarantee charge works. And that is a gap at the moment in terms of, we appreciate, I think the ATO would readily admit that it is certainly a big challenge overseeing and enforcing compliance across the entire workforce and across all employers, and allowing other avenues for recouping unpaid superannuation, we think would be valuable and would increase the capacity for employees to recoup their own money, and for those who assist them, including unions, for instance. But on that first question around the ATO's approach to penalties and compliance, I might hand over to James.
Thanks, Matt. So I think there's probably a couple aspects to this. The one is that, as Matt mentioned, there are issues probably outside of the ATO's control at the moment in terms of the policy parameters in which they're working, but there are certainly things that we think the ATO could be doing that would improve compliance. At the moment, the ATO takes quite a permissive approach to Part 7 penalties. I think in our opening statement we mentioned about 3/4 of penalties are fully remitted. And we think there's more of a role to play for penalties to be used as a deterrent. At the moment, that doesn't appear to be an approach that the ATO takes. It's sort of a bit of a perverse outcome where the ATO publishes its Part 7 penalty practice guide online, which is a little bit of a how-to guide to escape penalties, but at the same time, it doesn't, for example, publish its enforcement activities it doesn't publish its enforcement activities or examples of poor practice, but might actually act as a deterrent and reduce instances of unpaid super. So there's a few things that are fairly cost-free that the ATO could be doing. In terms of where it is a little bit handcuffed by the policy settings, evidence given by the ATO last week, already referred to, makes it pretty clear that the infrequent payment of super and the lag that they face just makes their job significantly harder to recover members' money.
Thank you very much. Senator Scarr.
Thank you, Chair, and thank you for the witnesses appearing today. A few points from me. The first one, I just want to drill down so I understand why it was originally that the system provided for a lag between the payment of wages and the payment of superannuation, because on the face of it you'd say, why wouldn't you pay them at the same time? It makes sense to pay at the same time. And it was a technical reason, Mr. Linden, in terms of being able to calculate it. Is that correct?
Yeah, well, look, I think if you look closely at the Hansard where these debates occurred when the original bills were introduced, I think we do need to recognise that this was a significant change for employers when the super guarantee was introduced, although there were obviously a series of award decisions which underpinned or were precursors to the super guarantee. It was a very significant change in policy, and I think at the time the government, although it had a very clear objective around ensuring that there's universal retirement savings for everyone, it did want to ensure that that businesses could manage effectively the transition where they may not have already been paying superannuation, and that seemed to be foremost in a lot of the debates around what the impact would be on business at the time, and that flowed through to some amendments to the bill which altered the payment frequency, and also to this issue which has recently been addressed pleasingly by the government with the 450 threshold. But I think everyone would recognise now we're a fair way down the track now from the introduction of the system. And as I said, the technology has come forward in leaps and bounds in terms of the way in which a business, even small and micro businesses, actually manage their invoicing and their payment of wages and super for their employees.
So because it wasn't done originally, we're now left in a position where if we were to make amendments or suggest amendments for it to be paid contemporaneously, small businesses may say, well, this is going to give us a cash flow shock when you introduce it. Is there some way it could be introduced incrementally or over time, or to help manage the alignment of the payment? Because I see from a policy perspective, it's clear as to what the benefits of that is.
Yeah, I think, and we have had some discussions with some employer groups about these issues as well. And, that's something which is front of mind, is how can you effectively manage a transition? Well, I mean, first you've got to make sure that there's enough lead time. I don't think anyone's saying you can make a change like this overnight. I think we could probably learn something from the way that single touch payroll was rolled out. So a single touch payroll, which basically provides a real-time view for the tax office around payroll of businesses, it was introduced in an incremental way. So the largest businesses had complied with single touch payroll requirements first, and then it filtered down to smaller businesses. So an approach like that could be considered, for instance, to ensure that there was an adequate sort of transition and ensure that there was sufficient time for employers to be prepared for these changes.
Okay. The Fair Entitlements Guarantee, I was actually surprised to find out that superannuation doesn't fall within the Fair Entitlements Guarantee. And I guess, again, what was the policy reason for that? The FEG was introduced after super came into effect. So the Fed covers wages, it covers annual leave entitlement, long service leave entitlement. What was the reasoning behind it not covering super?
I'm not sure there was necessarily a compelling rationale for why super was not included. I think part of the focus was on ensuring that employees had access to immediate entitlements and short-term entitlements, as you point out, annual leave, long service leave, I guess to a lesser degree, is less about an immediate entitlement, or unpaid wages, which had not necessarily been paid. I guess for government, because ultimately it's a Commonwealth scheme, there are budgetary impacts, and it may well have been a consideration when they were thinking about the original scheme design in terms of the breadth of what it covered. But yeah, it is. Would agree with you. It is certainly quite unusual that, in fact, the Fair Entitlements Guarantee does not cover a core entitlement like superannuation.
And so as I understand the FEG, it covers all your annual leave, all your long service leave, and 13 weeks of wages. So the proposition would be that the unpaid super should be aligned with the period of unpaid wages. Is that the thinking?
That's correct. Yes. So, in the event that there are superannuation liabilities which still need to be paid, then our view should be that it should be covered.
But if, say, you've got a situation where the employer hasn't been paying the super because they've been close to insolvency, or effectively they are insolvent, but they keep operating, and there's, say, an accumulated liability of 1 year's unpaid super, the FEG would cover 13 weeks of wages that are unpaid. Is your submission that the FEG should cover all of the unpaid super, or for a period of time it should be capped to the same period as the unpaid wages?
So I think these are decisions for governments in terms of the budgetary impact. In principle, okay. I think it should cover all of them. So, I mean, obviously long service leave accrues for much longer periods than 13 weeks.
Yes,
okay. And it's much more longer term in nature. So our view is that it should be over a longer period. But ultimately these are decisions about the design and ultimately what the cost of changes might be.
Okay. And my last question, and I know we've got to move on to other witnesses, but my last question is just this issue in terms of the ATO enforcement and penalties. So the practical scenario, and if I can put a practical scenario to you, and it's been a very difficult time over the last 2 years, 2.5 years with COVID. I've certainly seen small businesses, especially in the hospitality space, that have just struggled. So the scenario I'll put to you is this: you've got a hospitality business that had thought they had been paying the right amounts. We've got a complicated award system. It turned out they hadn't been, or for whatever reason, administration, they simply hadn't been paying the super they should have been paying. They're in a situation where with COVID lockdowns, etc., they simply have cash flow constraints. They're trying to meet the liability for the unpaid super over time, so they're trying to meet that liability. The ATO comes along and says, well, we can hit you with 200% penalties, etc. How do you think that the system should work in that practical situation? So I'm not talking about and maybe it's hard to draw a distinction, but those employers who willfully do the wrong thing, etc., as opposed to employers, small businesses who just get into trouble, right? And the ATO is then left with the situation: do I hit them, whack them with these huge penalties? In which case they might just say, it's all too hard, I'm walking away. Or do we try and cut them a bit of slack because we want them to keep operating and pay the super. Where's the right balance? How can you play King Solomon for us and find the right balance? Because I can see there are competing tensions here. You don't want to bring down a small business that's maybe employing 20 people. They're trying to do the right thing. They're trying to catch up. Maybe they're just chasing their tail and they're never going to catch up. But how do you find the right balance? Because you can legitimately see the situation when you're in that problem.
Yeah, look, I'd agree. I think that I don't think that we're arguing that, for instance, the ATO should not take into account the circumstances of, instances where there are underpayments. Clearly, there can be reasons why an employer may not fulfil their obligations in the Act itself. There's it considers things like natural disasters and the like, things which might affect, obviously, the business systems of an employer. Clearly, the pandemic has been a huge issue for many employers and in particular sectors, as you indicated. The funds, IFS, which is an entity associated with us, does undertake on behalf of some of the funds where they have agreements in place with employers some compliance activity, and they in fact paused that compliance activity during the course of COVID. So clearly a balance needs to be struck. I think probably what we are saying that certainly historically the concern is that in fact the ATO took a more permissive approach towards this. And whilst they do need to take into account individual circumstances, I think everyone would agree that, if an employer is, persistently underpaying or not paying their superannuation, and in fact the business is otherwise profitable, then, there's certainly on face value, very weak argument to say that, penalties should be automatically remitted.
Oh, absolutely, and I agree absolutely. If the owners are taking cash out of the business, they're earning profits and not paying the super. That's in a totally different category from my perspective to a business that's in legitimate trouble because of COVID. So, but okay, thank you very much. Thank you, Chair.
And I should just say to that as well, at the other end of the spectrum, the ATO does have fairly significant powers to enforce the Super Guarantee Administration Act, but it hasn't, as far as I'm aware, it hasn't really used its direction powers very much, or if at all.
Okay, thank you very much for appearing as witnesses today. That will be most helpful to our inquiry. And I'd ask that you now disconnect from the video conference, and if you'd like to keep watching, that you do so through the live stream on the Parliament website. Thank you both very much.
Thank you.
I'd like to now welcome representatives from the United Workers Union. Thank you for appearing before the committee today. You can turn your cameras on now if you would like. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise witnesses that answers to any questions on notice should be sent to the Secretariat by 5:30 Wednesday, 9th of March. And I invite you to make a brief opening statement should you wish to do so. For the Hansard record, could you please state your name and the capacity in which you appear?
Thank you, Senator. My name is Melinda Bolton and I'm an Industrial Officer for the United Workers Union, which is the Union for Early Childhood Educators. I'm also joined by two members of the union. The work of early childhood educators is essential work, and educators play a vital role in shaping the nation's future by educating and caring for our children. However, their work is undervalued and they are also particularly vulnerable to wage theft. Since June 2019, the UWU has represented a group of early childhood educators whose employer has consistently failed to pay their superannuation. After long court proceedings, the employer has now been placed into liquidation, and our members face the prospect of never seeing the superannuation they are owed. We have provided a summary of the case and written submissions to the committee, and I note these are in addition to the submissions previously filed by the UWU. I am also joined today by two UWU members who are a part of this case. They are identified as Witness 1 and Witness 3. Witness 1 is appearing by telephone and Witness 3 is appearing by video conference. And they will now make some remarks about their experiences. I believe Witness 1 will make some remarks first.
Witness 1, would you like to make a few comments? If you could unmute yourself.
Yes, sorry, I forgot to unmute. Witness 1. I am a member of the United Workers Union and I have worked as an early childhood educator for 17 years. I have worked at Gumnut Childcare Centre in Lithgow since 2008. My employer's failure to pay superannuation has impacted my work and personal life greatly. Because I have missed out on over 3 years of super, I will have to potentially work longer into the future so that I have enough money to retire with comfortably. When I found out that my employer wasn't paying my super, I felt angry and betrayed, as we were unaware for some months that this was occurring, as our pay slip still indicated that we were receiving super. As an individual worker, I didn't know how I could take steps to recover my super. I tried to get assistance from the ATO, but even when they performed an investigation, they weren't able to provide me with much information about how the super could be recovered. I have dedicated the last 14 years of my working life to Gumnut Childcare Centre, and I care a lot about the children and families I work with. But I feel betrayed by my employer and failed by the ATO for allowing this to happen for such a long time. I'm so frustrated that after such a long process, it seems unlikely I'm ever going to see the super that's owed to me. The system needs to change so that workers and unions have more power to hold employers in the early childhood education and care sector to account when they steal our wages. Thank you.
Thank you very much. And Witness 3.
Thank you. The non-payment of my superannuation by ECEC Management Services Proprietary Limited has impacted me and my retirement. I'm 59 years old and I don't have a long time to accumulate superannuation. I was out of the workforce for 10 years whilst raising my children. Every cent of my superannuation matters. It's not just the unpaid money, it's the potential earnings on that money that I've lost. Compulsory super is an obligation of employers to their employees. We should be able to trust our authorities to ensure that employers meet these obligations. The government can't afford to fund age pensions into the future. They need to be doing more to protect workers' entitlements. The non-payment has put unnecessary stress on me and my family at a time when I should be able to look forward to winding down my working life, not fighting for money that should be working for me. These companies need to be accountable and government needs to enforce these obligations and ensure strong penalties are applied to deter employers from stealing our entitlements. If I were to steal money from ECEC Management Services, I would be in jail. It needs to work both ways. Thank you.
Thank you so much, Ms Bolton, Witness 1 and Witness 3, and particularly to Witness 1 and Witness 3, thanks very much for coming along today to tell us your stories and tell us the impact that this has had on you. It seems like this situation has been a very stressful one, and your industrial officer, Ms Bolton, stated that this has been going on since June 2019. I was wondering if one of you might sort of step me through how you found out about your super not being paid and what your interactions have been with the ATO in trying to get the money back. Witness 1, did you want to have a go at that, or?
I can,
Yeah.
yes. So a fellow colleague told me that she had checked her super account and noticed that no payments had been contributed from our employer. So myself and other staff then checked ours, and we too had not received any, even though our pay slip from the time that they took over our centre, which was March 2018, we had, still been getting the amount shown on our pay slips, but nothing had been going into our super account. And so we, everyone contacted the ATO to make our complaint just by phone, and they told us that it would take a few months, they would look into it, and that was sort of pretty much where it sort of stayed there.
Okay, so is your evidence basically that after it went to the ATO, nothing much has happened since then? You haven't got the money back? Has there been much communication directly with you from the ATO?
No, we have not received the money. We received letters, maybe have got maybe 2 letters in the last 3 years, and that was sort of stating where they were at with their investigation. I received my last letter last week on Friday to say that it had been, it had been finalised, but still no payments.
Right, okay, finalised with no payment in the end.
Yes, that's true. Yeah.
Okay. Ms. Bolton, could you tell us a bit more about what the unions tried to do to pursue this lost super and what the prospects are of it being returned?
Yes, Senator. Since June 2019, we first began by assisting the members to engage directly with the employer. So we assisted the members by writing effectively what was a letter of demand asking for the super that was owed to be back paid and for them to begin paying super. When that wasn't responded to, we then worked with the members to investigate how to make complaints to the ATO. The members undertook those complaints individually. We also wrote to the ATO to attempt to communicate with the ATO on behalf of the members as their representative. The ATO they weren't able to provide much information either to us or to the members. When it became clear that the employer wasn't going to rectify the situation, that the ATO it wasn't clear to us what action the ATO was actually taking, if they were taking any action at all. That's when we decided to file proceedings in the Federal Circuit Court on behalf of the 10 members who were affected at the centre at the time. Those proceedings, we filed those in February 2020. They were finalised in September 2021. We received orders in June 2021 from the Federal Circuit Court. Those orders required the employer to back pay the super that was owed from March 2018 up until June 2021. Then in September 2022, we received further orders from the Federal Circuit Court in relation to pecuniary penalties to be paid to the UWU for the breaches of the Fair Work Act. Following those orders, the employer still didn't make any payments despite the court orders. They then chose to file an out-of-time appeal in the federal court against the orders in relation to the pecuniary penalties. That was essentially further cost and time and resources for us. Though then earlier this month, we received confirmation that the employer has now been placed into liquidation. So at this point, the prospects of our members receiving the superannuation that they're owed prospects seem relatively poor. Our members are now reliant on the investigations being undertaken by the liquidators in relation to the assets that the company held to see if there's any possibility of the superannuation being paid from any assets that might be able to be liquidated.
Okay, I'm really sorry to hear that outcome. And witness 1 and witness 3 have talked about the implications for them and their retirement. And I think I'm sure we're all really sorry to hear that may be the outcome. Ms. Bolton, you talked about the federal court process. I was just unclear whether the ATO ever sought to enforce compliance with the company prior to you going to the federal court, or do you just not have information about that because you don't sort of have standing, witness 1 and witness 3, and yourself as the union don't have standing with the ATO?
We have very limited information about the action that the ATO were taking prior to our filing proceedings. We were advised by the ATO via phone, it would have been before February 2020, that the employer had agreed to enter into a payment plan for the amounts that were owed up until that point. But our members and the union, we weren't provided information about the time frame for that payment plan, or even whether any payments had actually been made.
Okay. I think I could ask a lot more questions, but in the interests of time, I'll go to you, Senator Scarr.
Yeah, thank you very much. Ms. Bolton, what were the reasons the employer gave for not paying? So you had to go to the trouble of instituting federal court proceedings. Did they lodge a defence, or it would seem to me that it's the obligation to pay superannuation is pretty clear, pretty fundamental. Did they have any defence? What could the defence be?
Senator, the employer didn't seek legal representation throughout the proceedings. They were self-represented. So while a defence was filed, it was relatively slim. Their defence essentially throughout the proceedings, they admitted to not paying the superannuation. Their reasons for not paying it, the gist of it was essentially that they couldn't afford it. The business was in trouble and they couldn't afford it.
Okay, so that's no defence, right? So from a legal position. So how long did it take? I just want to get the timing right, because it seems a long time. You filed when in 2020 did you file?
February.
And then you didn't get the orders until June 21, is that correct?
Yes, Senator.
So there was no opportunity for you to, and I'm a lawyer by background, right? So there was no opportunity for you to seek summary judgment or some sort of accelerated judgment to get the judgment more quickly, given they really had no defence, right? So it shouldn't have taken long for a judge to deal with it summarily and give you the order, which would have allowed you to take additional further steps, right?
So the proceedings were set down for mediation, as the judge, I believe, was hopeful that the matter could have been resolved at mediation. Unfortunately, it wasn't resolved at mediation. That was a without prejudice conversation during that mediation process, so I'm not able to go into the details.
No, that's fine.
Yeah, but essentially, we weren't able to get a summary judgment, no. As I said, they were self-represented, and
which makes it difficult. I've been involved in those situations, and it's a lawyer's worst nightmare dealing with another side which is self-represented. So, in terms of the liquidation, has the ATO or ASIC indicated that they might be prepared to, for example, fund investigations in relation to insolvent trading against the directors? So in a situation where you've got admissions of insolvency, in effect, in terms of the defence, the directors of the company, I presume it was a company, can be liable for insolvent trading. Are there any resources to look at those avenues of getting damages against the directors and access to assets which are outside of the company?
Senator, we've received no indication from the ATO or ASIC that they are investigating that course of action. Our members have actually received letters recently from the ATO, as Witness 1 mentioned, advising that they have closed our members' cases and that they, at this stage, don't intend to take any further action in relation to them, and that it is now up to the company and the liquidators to advise the ATO of any outstanding superannuation that is owed.
Okay. And in terms of who actually appointed the liquidator?
So the company, as far as we're aware, the company had other debts that it wasn't able to pay. So it was, the liquidator was court appointed as the landlord of the property they're renting had filed a winding up application in the federal court.
Okay. I was keen to ask Witness 1, how long were you continuing to work for the employer for Gumnut whilst you weren't being paid superannuation? And you knew you weren't being paid superannuation?
The whole time. So, as I stated before, I started with Gumnut back in 2008. I'd worked with previous owners, and then when ECEC took over in March 2018, it sort of was just a very stressful situation after that. But because I loved the place so much, it was hard for me to walk away from that.
So it was when the new owners took over, is that when the superannuation stopped being paid?
Yeah. Yes.
Okay. And what do you, I'm just interested, and I really do compliment both of you, both the witnesses, for being brave to come and share your testimony, because it really assists us to gain an appreciation of what someone does in this situation. So you became, Witness 1, you became aware that the superannuation wasn't being paid because of one of your workmates checked her super fund or their super fund and found that out.
Yeah.
So you then presumably raised it with the manager or the owner?
Yes, I did. So I had called him and had spoken to them and said, that we were concerned why hadn't we received any super. His response was that we are working with the ATO to resolve the issue. And that was sort of all I got told.
Okay, so there was no communication with you from the employer as to this supposed payment plan that was agreed to with the ATO. There was no communication directly with you from the employer?
No, nothing from them, no.
So, and you felt you couldn't, and presumably all the employees, how many employees were there?
We've sort of changed over the years, I guess, the amount of employers that have lost a few because of the super issue. But I think at the time, Melinda might have to quote me, might be between 10 and 13.
Okay, so you're all in this situation, and you keep working because you didn't feel as if you had a choice, and or you actually enjoyed working there. Is that right? Yes,
it's because I've worked there for so long, and it's just been like a second home to me. And I was working because of all the families and the children that I care for. And yeah, I just sort of felt betrayed the whole time, but I was only staying because of those families and those children.
Yeah. Okay. All right. And then witness 3. So how long were you working for ECEC before they didn't pay your super, or did they never pay your super?
They never paid the super.
Okay. And again, what did they actually say when you raised it with them?
That they were working on a payment plan.
With the ATO?
Yes.
But they never gave you any information as to what the payment plan was?
No, we didn't
The
know.
ATO didn't give you any information as to what the payment plan was?
No, I think I got 3 letters all up from the ATO basically saying they'd received the complaint, they were working on the complaint, and now the complaint's closed.
So I guess in my mind, this raises a question of, this is your money, right? The superannuation should be your money, and yet the ATO is the one organising the payment plan with the employer, and you don't seem to be involved in or employees don't seem to be involved in either that negotiation or being told what the payment plan is or the details of the payment plan. Is that a correct observation?
Yes.
Okay. All right. So, Ms. Bolton, that strikes me as the money is the employees, right? So you've got the ATO who's working with the taxpayer, the company to work out the payment plan, but there seems to me a bit of a disconnect that the ATO's simply advising the employees that they're working on a payment plan, but it's the employees' money. Where do they get the say as to whether or not this is an acceptable payment plan or not an acceptable payment plan, or what the details are? Is that a concern?
Yes, Senator. That's been a great frustration of our experience throughout this entire process, including the enforcement process after we received the court orders, because the superannuation amounts owed are technically not owed directly to the members. They're owed to the superannuation funds being held in trust, which means that as we've got court orders stating that the employer needs to pay the outstanding superannuation, when they don't make those payments, we have very few enforcement possibilities for those court orders because we're not the super funds.
But the super funds themselves, do they have limited enforcement opportunities as well?
So we have reached out to the super funds throughout this process as well, and received little communication from them. I'm guessing potentially they receive a lot of requests such as these for assistance. Yeah. I'm not across what their options are in terms of enforcement. Okay.
All right. Okay. Thank you, Ms. Bolton. Thank you, and thank you, witness 1 and 3, for giving us your testimony. It helps to draw it out into stark relief the impact, the personal impact this has on people. So thank you very much. Back to you, Chair.
Thank you very much. And I just did have one final question for you. I note that you've made a submission to the committee about this case, and thank you for that. And I'm just looking at that, and it says that it was in December 2019 that the ATO advised that there was a payment plan in place on page 3, and that the superannuation was still not being paid at that point, and the debt was continuing to grow, and the members were advised by the ATO that they would need to file a new complaint each quarter if the company continued to not make superannuation contributions. That seems extraordinary. So you're chasing up a historic debt, and then the debt is still growing, but you have to wait for that debt to further accrue and then file new complaints about it. Is that what I understand from that?
Yes. Essentially, members had to wait until the end of each reporting quarter to make a new complaint.
Right, okay. And just finally from witness 3, what's your message to government really about this? I mean, do you think that enough is being done or more needs to be done to make sure this doesn't happen to other people?
I think more needs to be done. this company seems to have been able to thwart the system consistently. Like they've had 4 years to sort this out. They put in a tender to take on the business, and if they didn't have the funds to actually manage that business, what was their purpose in putting in a tender for it? They would have known what the wages bill was. They would have known how much the super was. Where's their budget? And if the ATO hasn't done anything, what's the point in the law?
Okay, I think that was pretty clear. Thank you very much, Witness 3. Thank you again, Witness 1. Thank you, Ms. Bolton. Thank you all for appearing today, and that I ask that you just now disconnect from the video conference, and if you'd like to keep watching, to that on the Parliament website. I now welcome representatives from the Australian Taxation Office. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise that answers to any questions on notice should be sent to the Secretariat by 5:30 Wednesday, 9 March. I invite you to make a brief opening statement should you wish to do so. And for the Hansard record, can you please state your name and the capacity in which you appear?
Good morning, Senator Walsh. I'm Emma Rosenzweig. I'm Deputy Commissioner for Superannuation and Employer Obligations at the ATO, and I'm joined by my colleague, but we do not have an opening statement. I'll let her state her name for Hansard though.
Okay, thank you very much, Ms. Rosenzweig, and I note that we've got Ms. Allen there as well. Thank you both for appearing. And Senator Scarr, would you like to start?
Sure. Ms. Rosenzweig, we were talking to some employees who are in an actual position where their superannuation wasn't paid. They became aware that their superannuation wasn't paid. And then they started this process of making complaints to the ATO. One of the issues which emerged from that was, in my mind, was when the ATO is having a negotiation, if you like, or a discussion with the employer around how to resolve these issues, including payment plans, etc., to what extent are you able, under the existing law, to actually give substantial information to the employees as to what the payment plan is, how long it's going to take for their unpaid super to be met, what action the ATO is going to take if the payment plan is not adhered to. So this issue of the employees for whose benefit the superannuation is being paid, and who ultimately have a beneficial interest in the super funds, even though it's paid to a trustee, it's held on their behalf for their benefit. To what extent are you, under the current law, to actually provide what I consider to be the fundamental information that they should perhaps have an interest in terms of payment plans? How much per month, and how long is it going to take to be repaid?
Thanks, Senator. So I know there was some discussion about how much we engage with employees. So we do inform, as the employees you were just mentioned, we do inform employees when we have started a case, when we have raised a liability, which, you know, depending on the complexity of the case, can take some time. And then again, when we have collected any funds for them to pass on to their superannuation funds. So we do have a process to keep them informed of that. I don't think it is our normal practice to actually give them details of the payment plan that might be put in place if an employer can't pay it all in one go. But I can certainly take that on notice to check whether there is actually anything that would prevent us from doing so. It may be a case of that just something that we have not, you know, as a matter of course, done. I will say though that it is I think a few people have mentioned to you this morning some of the structural challenges with super guarantee, and I think it is one of the natures of using the tax system and the tax legislation to administer the superannuation guarantee that we end up with a position where the employees themselves do not have direct standing in that matter. However, there have been changes over the years to allow us to provide more information to employees about that. So it's effectively the way it's set up, it's effectively a tax matter between the tax office and the employer. And we have some special rules that give exemptions to the normal secrecy provisions that allow us to keep employees informed of that progress.
So the issues that arise in my mind, and I understand the complications arising from it being a taxation matter, but if you've got 10 or 11 employees in a business who haven't been paid, say for 3 years, the outstanding liability could well be, say it's $1 million, and the payment plan is, say, over 2 years or 12 months. I'm not sure what the parameters are around payment plans. If the do you recognise that if the employees actually have the information as to the key elements of the payment plan, they're then empowered to make an assessment themselves as to whether or not it's likely to ever be met? Because on one analysis, the employee should have the information needed to make their own assessment as to whether or not it's in their best interest to actually stay with the employer or look for alternative employment. And if they don't have the details around the employment, around the payment plan itself, they're deprived of that information, which I think they reasonably need to make an assessment as to, am I going to stay here? Should I look for another job? Do I need to cut my losses? Because every day they're there and they're not earning their superannuation, they never get that time back. They never get that time back. They're deprived of that time and the benefit of those superannuation, that superannuation accumulation. Do you see that? Do you see that point?
Absolutely, Senator, and I'm happy to look at whether there is more we can do to actually inform employees about the nature of the payment plan. I will say that we do contact employees each time we receive a payment. We collect an amount for them and we're transferring that to funds for them. And as a couple of people have noted, there have already been, over the last few years, a number of changes to allow employees to actually track contributions that are made for them through using ATO Online. So I know that they can check in through that mechanism as well to see what contributions are being paid to their super fund. So there are a couple of ways that employees can keep track.
So I understand that, and I'm just trying to get my head around exactly the information you get. So say for example, I made $20,000 in superannuation, and there's 10 other employees like me owed $20,000. The payment plan is that's got to be paid over 12 months. So each month you should receive the superannuation you're entitled to that month, plus 1/12 of your outstanding liability. So the amount that should be in your account each month should be whatever the figure is. Do you go down to that granularity in terms of the information?
We don't, Senator, at the moment. I've said I'm happy to take it on notice to look at what further information we could give an employee. But Senator, the way super guarantee charge is calculated, it will change month to month. There is an interest calculation in the super guarantee charge, and so it will, if a payment on the payment plan isn't met, for example, then the calculations for future months may change as a result. So we would have to think about how we make sure it is simple for people to understand. It's not adding more confusion, but it's, as you say, it's giving them additional information to help support them understand what's going on. So I would have to take that on notice to look at what is possible. for us to provide a bit more information to employees there.
Okay, so just from, and this is an important point before I hand back to the chair, and I'm taking some time to tease it out. From my perspective, if an employer is in this position, because it's the employee's money, right, they should have a right to know what the particular amounts due are each month and whether or not those amounts are being paid in accordance with the payment plan or not, and also have basically have the information they need to make an assessment as to whether or not they should still be there. Because if the employees are probably as best positioned as anyone to work out if the business is sustainable. And every month they're there not earning superannuation or at risk of not earning superannuation is time they'll never get back. So I think that's a key point from my perspective, understanding what information the ATO provides, what information the ATO could provide, so the employee is getting on a month-by-month basis the detail around whether or not the payments they're receiving are in accordance with the payment plan or not, to the extent they're not, and perhaps even what the larger picture is in terms of the unpaid super, so they can make an assessment as to whether or not to seek another job instead of just turning up one day and finding the gates are locked. That seems a really important point to me. But you'll take that on notice, so I appreciate that. I think you understand the issue, and with that, I'll hand to you, Chair.
Thanks, Senator. I just wanted to follow up on the question that one of the previous witnesses raised around the fact that in this particular case, and I understand you don't have the details of this particular case and probably can't comment on it, but it seems that a payment plan was entered into at the end of 2019. There were lots of issues around communication and standing of the people whose money was owed to them that Senator Scars spent a lot of time on. And in addition to that, it seems to have been the case that the superannuation was still not being paid, not just the debt, but the ongoing entitlements for people who were still employed were not being paid. Is it your understanding then that people would need to sort of keep being underpaid and wait for the quarter, wait the 3 months, and then file a new complaint on top of their existing complaint that's underfoot? And if so, do you think that's sort of a reasonable practice?
Senator, what I would say is we're actually working hard to get better with our use of data. So the data that we get, as you know, in 2019, all small businesses began reporting through single touch payroll. And that allows us now to have a much better picture of the, along with the data that's reported through super funds about the contributions that they actually receive. It allows us to have a much better picture, and we are working hard to actually do more and more with that data to be able to be more proactive. In the last financial year, we did undertake a significant proportion of our cases, so over 3,500 cases that we initiated about employers underpaying superannuation amounts to employees, and we hope to grow together. So, Senator, I would say historically, you know, we probably have asked people to do that, but as we get better visibility, I would say that is, you know, would be decreasing, that we would expect people to do that, because, you know, I understand that is pretty frustrating for some people to hear that message.
Okay. I think just one further question. There's been a lot of discussion this morning around the ATO's powers and whether you have enough and whether you use them enough. In your submission, you noted the power that you have to make a direction to pay, which I think is perhaps new in the last couple of years. At the time you made the submission, which was a while ago, there hadn't been directions to pay. Have there been directions to pay since then, and what information can you give us about the numbers of those directions and whether they've been successful?
So, Senator, since we made our submission, I think that was late 2020, we've obviously still been working with businesses through the impacts of the pandemic. And I know in other testimony to Senate estimates and other forums, we've talked about the fact that we have not aggressively pursued debt collection, and we've been trying to work to support businesses to sustain them through the pandemic. So we have not actually, since our submission, used that direction to pay power. As the Commissioner said at estimates last week, we are starting to renew our activities in debt collection and re-engage with businesses who owe us money. And as part of that, we are thinking about the full suite of tools that we have available and when it's appropriate to use them. And the directions to pay for Super Guarantee, as you know, they're reasonably new. They came in just before the pandemic hit. And so I guess we've sort of had a bit of a delay before we really think it's appropriate to start pulling them out as one of the tools in our kit. So they will be part of the things that we factor in going forward with businesses.
Would you say that the ATO has a zero tolerance approach for employers not paying their super, or do you have some other sort of approach that says in some circumstances it seems to be okay?
I think we've always said it's entirely unacceptable that employers would underpay their super. I know we've talked about some of our understanding about the drivers behind that and the types of behaviours. And we see a range of behaviours that lead to employers not paying their super, right from deliberate intent, right through to a business who is maybe a brand new employer and just gets something wrong. And we have to work across that spectrum. And I think Mr. Linden, who was talking to you before, also acknowledged the complexity of the range of behaviours that lead to the underpayment of super. But we take it very seriously. We investigate absolutely every single person that comes to us to tell us that they have been underpaid super or they think they've been underpaid super. And as I said before, we're getting better at using the data that we have available to be more proactive with employers. We do have a practice statement that talks about our approach to the remission of penalties. And I will say, super guarantee charge already, the way it's calculated, is calculated to be more than the original super contributions would have been. The nature of the calculation itself is a penalty. And there are quite a number of elements of that we are not able to remit. The Commissioner has absolutely no scope, and that is often something we are challenged on or criticised on, but we have no scope to remit them. The Part 7 penalties are amounts that do not, they're purely punitive aspect of the scheme, and they don't get passed on to employees. So the decision by the ATO to remit those penalties is not something that disadvantages the employees. And it is something that we have outlined in our practice statement, the factors that we think about, trying to reflect that spectrum of behaviour we see and trying to reflect the fact that some employers do attempt to comply with their obligations by paying late, right through to those employers who deliberately, with intent and repeatedly, don't contribute. So our practice statement tries to find the right balance and the right approach to penalties for all of those behaviours.
Thank you very much for your evidence today. I think that concludes the evidence from the ATO, so thank you very much.
Chair, could I ask just one quick follow-up?
Well, you'll have to be very, very, very quick, Senator Scarr, okay?
Can I just ask you, in a situation where liquidators are appointed to a company, what consideration do you give to fund the liquidator to make investigations, conduct inquiries to look into things like insolvent trading by directors and ascertain whether or not there are assets that might be available to meet the unpaid superannuation liabilities.
Senator, I'd probably have to take that one on notice and check in with our debt team about the processes we use, but we participate actively in insolvencies as other creditors. And I will note that super guarantee is prioritised in an insolvency.
Okay.
But I will take your specific question on notice.
So I'm interested to know the extent to which you do fund liquidators to make those additional inquiries to see if the officers of a company have assets which might be able to be accessed through insolvent trading provisions to meet these unpaid liabilities. Okay, thank you. Thank you, Chair.
Thank you, witnesses from the ATO. I'd like to invite you to disconnect, and if you'd like to continue watching, to do so from the Parliament website. Thank you very much. I now welcome representatives from the National Tertiary Education Union. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise witnesses that answers to any questions on notice should be sent to the Secretariat by 5:30 Wednesday, 9 March. Thank you all for being there. I invite you to make a brief opening statement should you wish to do so. For the Hansard record, could you please state your name and the capacity in which you appear?
Thank you, Senators. My name is Alison Barnes and I'm National President of the National Tertiary Education Union. Thank you for the opportunity to appear before you today. And I want to speak about the National Tertiary Education Union's experience of systematic and chronic underpayment of higher education workers. The NTU has made a submission to this inquiry and provided evidence last year. So I'd like to use this opportunity just to update the inquiry on the problem of underpayment more recently and what workers across higher education have experienced during COVID. As you'll be aware, the university sector has been particularly hard hit by the COVID pandemic. The collapse of international education, which universities relied on to subsidise teaching and research, was followed by the government's disastrous Jobs Ready graduate package, which stripped even more funding from our university during the worst financial losses ever seen. As a result, we saw thousands of job loss. Some estimate that we have lost up to 35,000 jobs in our public higher education institutions. That's jobs, not full-time equivalents, which is how the government and university management prefer to calculate the hard-working people who provide the teaching, research, and support thousands of students across this country. In doing so, it hides the real numbers of university employees. However, the NTU is very much aware of who the workers in our universities are. It's a feminised industry, but not at senior management levels. It's one that relies on insecure employment, with only 1 in 3 jobs permanent. It's also one where underpayment or chronic wage theft is systematic and widespread. In 2020, the NTU undertook a survey of 2,174 professional and academic staff, and at every university except Charles Darwin, almost 4 in 5 academic respondents claimed one or another form of underpayment. In October 2021, the Fair Work Ombudsman was investigating 14 institutions over underpayment. We welcome the spotlight that is now on universities' employers. However, the NTU has been pursuing pay justice for higher education workers, be those academics or professional staff, for many, many years. Underpayment is a core concern of the NTU. We've run campaigns, taken industrial action, pursued claims in enterprise bargaining, raised disputes in Fair Work, exposed the injustices in the media, lobbied politicians, provided briefings, made submissions and appeared before inquiries. It's taken thousands and thousands of hours of work, and it's resourced by NTU delegates, by our activists, by our members, by our casuals, and by staff and union officials. This work has been hard, but we've had wins, recouping millions of dollars. In the last few years, just from universities appearing before you today, we've recouped around $35 million. And this is being refunded to staff, mostly casuals who've been underpaid. And this, unfortunately, is just the tip of the iceberg. That it is primarily the most precariously employed who are the most vulnerable to wage theft is not a coincidence. There is a clear link between underpayment and job security. Insecurely employed workers are seen as the cheapest labour. They are the least likely to speak up should they be accidentally or deliberately underpaid. They're often fearful of losing what little work they have or they hope to get, and universities have essentially profited from this fear. Despite these concerns, we have two witnesses here today, David and witness 2, who has requested that his name not be used, to provide evidence to this inquiry of underpayment and talk about their own experience. David can speak not only of chronic wage theft, but demands for repayment by his university management, who, through an administrative error, overpaid him and dozens of others. Even worse, over Christmas and the New Year holiday period, the university sent emails of demand to his university account. No, he wasn't employed by the university at the time, and then engaged debt collectors to recover a few $100s while owing him thousands in unpaid work. Our other witness from the same institution has also had similarly outrageous experiences of the university not only underpaying him for the work he undertook, but also actively preventing his conversion to permanent employment, despite him having worked the hours that would have otherwise triggered conversion. This was done by reallocating his teaching to a permanent staff member, except this academic already had a full workload. So his classes, in which he was the expert and had taught for many years, were reallocated to other casuals. Both David and witness 2 have provided witness statements to the committee outlining their experience in details and the impact the actions of their employer has had on their mental health, their financial security, and their hopes for a productive career as academics teaching our next generation of students and professionals. I also wish to table in support of David's account the letter of demand made by university management regarding the alleged overpayment of a few $100s that affected David and others. Myself, I and our Acting Director of Industrial and Legal, Kelly Thomas, are happy to answer any questions you have. However, given we have a short time, I hope in the short time we have that you have the opportunity to speak to our two witnesses. Thanks very much.
Thank you very much, Ms. Barnes. Could I just clarify whether Mr. David X, as I understand he's wishing to be referred to, and witness 2 had an opening statement, or are you just inviting questions to them based on what's been submitted?
They've submitted opening statements, which they're happy to read, but given the short time, the time constraints, we wondered if you'd like to go straight to questions.
Okay. Thanks, Dr. Barnes. I'll go to Senator Faruqi.
Thank you, Chair, and good morning, everyone. And thank you once again, Dr. Barnes, Ms. Thomas, and especially Mr. David and witness 2. I know how much work has gone into these inquiries, and especially trying to fix the systemic issues of casualization and wage theft. So I might start with you, Dr. Barnes, if that's okay. In the NTEU statement, it says that $35 million has been refunded from just the universities in terms of wage theft, from just the universities who are appearing today to give evidence to this inquiry. Do you have figures for what has been returned overall to date?
Sorry, Senator Faruqi. Those we can track those figures, but they're hard for us to keep track of because often, for example, local branches or or university-based branches will, for example, send emails to management and report wage theft, and they don't necessarily report that to us. So tracking how much we've won is difficult for the union, as it is also difficult to track the huge amount of resources that we spend on, fighting, against, wage theft because of the hours, for example, that people put into kind of talking to themselves, organising and the like. So I will take it on notice and we will provide you with the most accurate data we have, but it is likely not to be a complete set of the data for those reasons.
And it shouldn't really be your job to do this. Universities should. Anyway, we'll move on from there. Since you last appeared in this inquiry, it's been almost a year. And since then, there has been university after university who has either admitted to underpayments or has been forced to admit to underpayments. And, I'll just read out some of the headlines that have come through in that year. UNITAS apologizes for underpaying staff, RMIT to stump up back pay for academic casual staff, new underpayment claims at Monash, and it goes on and on. And as you said earlier, Fair Work Ombudsman in, I think it was November 2021, said they were looking at 14 universities, investigating 14 universities. Are there any more over and above that you are looking, over and above those 14 that you are looking into at the moment?
Well, we know from that survey that I briefly mentioned that wage theft is common at every university except Charles Darwin across the country. So for the NTU, it's, in each of those universities, workers, organising workers to come together and organise to stop wage theft. So it's one of our core campaigns. So we're being vigilant at every campus, in spite of the drain on our resources and the energy of our members and our delegates that extended. But we're absolutely aware that apart from those 14 universities, that wage theft is both systematic and appears to be the business model upon which our public universities appear to be running.
Why do then universities keep saying, and they have kept saying that to us over and over, it's a mistake here, it's an error there, sorry, it's something to do with the payroll and mistakes were made. Why do they keep saying that? Have they actually changed their tune on that as far as you are aware? Are they getting serious about changing the systems that lead to this?
Look, I think it's a case of the reality and the rhetoric. There's a lot of rhetoric around universities trying to do better, fix their payroll systems, but the reality is we have instance after instance of wage theft occurring across our university. And I think David's story really highlights how common it is and how, in spite of the good work of this inquiry, the intense media interest in universities, wage theft is still occurring, and and as I said, is widespread. And I think David's story really highlights that.
And I do want to come to you, David, and thank you very much for giving us your statement. It is absolutely heart-wrenching, I have to say. Your account and your treatment by the university that you have taught in with such passion and with such love. So could you just elaborate a little bit on this and about the free labor that you talk about as well, that you have been giving for years?
Absolutely. Thank you, Senator, for the question. So I've been teaching at Swinburne University for about 6 years now, or just under 6 years. It's a job I'm very passionate about with students that I'm very passionate about teaching. The problem with the sector is that it relies on my goodwill and my love for teaching and my care for the students to do work that would be minimum requirements. This university itself doesn't pay me to meet those minimum requirements, so to speak. So if I'm supposed to give good feedback on an assignment, I'm supposed to give detailed understanding and focus to what a student is creating or making, or if they're having out of hours issues or problems. I mean, over the last 2 years, I can say quite clearly that I have had, tens of students come to me with mental health problems, with economic problems, they turn to, and a number of these are international students as well, who seek my guidance on how to help them navigate either the bureaucracy of these universities as well as the day-to-day lives of a COVID student. But this goes way beyond COVID as well. I'm underpaid in almost every aspect. Now, the catch-22 with this is, if I did my job according to the standard to which I am paid at the university, I would be considered a pretty poor teacher. The university then could turn around at me and say, well, you're not very good, your student feedback doesn't give you a very good recommendation, and therefore we can let you go. So it relies on me kind of needing to prove to them constantly that I'm good enough to be employed for another semester. And if I don't do that, then I am technically working to their standard or to what I'm being paid for, but I have the risk of being let go.
And despite, I guess, casual staff being paid underpaid by thousands upon thousands of dollars, university then sent debt collectors after you for $300 and something that you owed them.
Yes, that's correct. So it was about $332.82. It's burned into my brain, that number. They attempted to contact me during the Christmas period with a single phone call. Now, as Dr. Allison has mentioned previously, I'm not employed at the university during holiday breaks. I'm only employed during the semesters that I teach. They tried to call me. They left a message. I tried to call them back and received an answering machine. They said to look out for an email over the next couple of days from a Nancy Collins. I then checked my emails over the next couple of days. No such email arrived. And so I went back. I refused to continue working for them, i.e. checking my emails, because I'm not paid to do that when I'm not working for them. I then started work again once I was contacted by my boss and received 2 emails. The date that I checked my emails, I believe, was the 20th of January, and I'd received an email on the 7th of January and an email on the 18th of January. The first email on the 7th said that I had been overpaid by an administration error and that I needed to pay back at my best convenience by the 30th of January. It was very cordial and it was absolutely polite, I would suggest. But the second email, which was on the 18th of January, was much more sterner, requesting that I have avoided their attempts at contact, which I hadn't, and also that they would be sending debt collectors after me and that might affect my credit score. Now, I'm sure all of the senators are aware that getting a house at the moment is a very, very difficult process, and I'm trying to save up for a house, and credit is an integral part of obviously getting a loan. I'm the sole breadwinner of my household due to COVID for a number of years, and the idea of a debt collector coming after me and potentially affecting my credit score is absolutely terrifying. And so I immediately, and they had changed the dates. Not only had they changed the dates from the 30th of January, but they reduced it by 6 days, saying that I had to contact the debt collectors and not the university anymore by the 24th of January, which left me kind of bereft. Again, it felt like I was just a number. I was not a person, not a teacher, at an institution that really didn't care for me. And it really put a sour taste in my mouth, knowing how much unpaid labor I had done them over the years and how little patience they had provided for me.
It's pretty outrageous. And we've heard again and again from casual uni staff how that impacts their life every single day. If I could go to witness 2, in your statement, you've said that the department chair asked your unit convener to not employ you in the second semester. Just wondering, why do you think that was the case? Was it also to do with some sort of, I don't know, repercussion because you spoke out and demanded what you were owed?
Witness 2, if you could unmute yourself, please.
Thank you, Senator, for your question. As my colleague, I'm working for Swinburne University for the last 6 years. The problem started in 2020 when the university moved to the online learning. At the end of the year, I applied for conversion. So basically, I realized although I have done tutorial hours, that I was paid on lab basis or lab rate. So basically, the department chair instructed the unit convener not to give me any classes in the coming semester in order to avoid my conversion. In my belief, maybe it's related because I spoke up. I said this is not fair payment. I didn't get my fair payment for last year, and this is maybe a combination from both things. But in my belief, mostly it's related to conversion because I'm doing these units for the last 5 years. The number of hours almost same, more than 150 hours for each calendar year, except last year, which is I'm eligible for conversion. They dropped my hours from almost 200 hours to 62 hours in the first semester, and I allocated by the unit convener again in the second semester 2021 to do more than 50 hours, which will be enough for me to get the minimum requirement for the conversion, but they canceled everything just before the start of the semester, 2 days before the start of the semester. Again, I already lodged a formal complaint in the first semester through the union. I said I will be targeted in the coming semester to human resources in the university, but unfortunately, the university failed to investigate my allegation. When they canceled my classes, I went to them again. They said, we didn't cancel your classes because we targeted you in order to avoid the conversion, but we want to save some money teaching this class, which is wrong because the hours that taken from me to give to the permanent staff is our giving to another session. So basically, they just play around in order to avoid my employment.
Yeah, so there was no money saving.
No money saving at all. I went to I tried to talk with the department chair and the dean in the time. I said, look, I'm working for Swinburne for the last 6 years, maintaining good feedback, students' feedback, and especially during COVID-19, as my colleague said, we used to give more time from our free time in order to support the students. We moved to online learning, but the students needs more help during the online learning. It's not normal situation we went through during the pandemic and 2020, especially 2020. But they don't care about all this. At the end, they have to see our feedback is good, which is we maintain this feedback, students' feedback, which is especially the last 2 or 3 years. I have more than 9 out of 10 students' feedback. They don't look at this at all. They don't look at my my work in the previous years. They just want to avoid my obligation. And as a casual, I have no chance to stand in front of university. They have lawyers instead of lawyer. I went to Fair Work Commission. They said you can represent yourself, but at the end they said, okay, you need to submit your case in court form. I have no knowledge to do this. I went to lawyer. They said we will charge you 20,000. I can't afford to pay 20,000 to support my case, so I have to drop my case from the Fair Work Commission. And then even my payment, which they owe me they have to pay me from 2020. They agree at the beginning of the dispute to pay it back, and then after I dropped the case, they said they pay me only 1,500 out of 6,000, and they said we will not give you. This is your money, and we will not give you anymore.
Thank you so much for telling the committee about the real life repercussions of this business model that universities have at the moment. The chair's just given me a warning that I have one more question. So if I could come back to you, Dr. Barnes, I know that there's no NTE representative from La Trobe Uni here, but I just wanted to ask a question in case you had some insights into that.
Yeah.
Just yesterday, there was yet another news story where La Trobe University has now admitted to underpaying casual academic staff by another $2.5 million, which is related to marking and exam assessments. And the NTEU branch president at La Trobe has said, La Trobe's management's proposal is a hack job that will fail to cure most of the non-compliance, fail to ensure future compliance in respect to casual academic marking, and deliberately exclude the involvement of the union and casual staff because it's more interested in a speedy process than actually backpaying stolen wages. I'm just wondering if you know anything about it that you could elaborate on for us, because it doesn't seem from this statement that La Trobe University is actually serious about addressing the systemic issues.
Senator Faruqi, I see on the screen we have Anastasia Kanjara, who might be appearing next. She's from La Trobe University, so she's probably well placed to talk to, what it's like the lived experience for workers at La Trobe. But I think the point that the branch president's trying to make is the one we were talking about earlier about the experience across the sector and that reality versus the rhetoric. All university management across the country make the rhetoric that they are dealing with the issues of wage theft. But cases like La Trobe or Witness 2, being so fearful that he is not prepared to use his name, are really damning indictments of the realities that casuals across our sector face. That the rhetoric, as I said, does not match the reality. And universities, I think, university management have the power to fix their pay system. They have the power to change the way people are employed. They have the power to do all sorts of things which would lead to secure work across the sector and fundamentally tackle the problems of wage theft, yet they choose not to. They choose to continually exploit people like David and Witness 2 and other casuals who are appearing today. And I don't see, given how hard university management fight us about changing the employment conditions that give rise to wage theft, and I'm talking about insecure work, how hard they fight us on that university management really are prepared to tackle this problem across our sector.
Thank you. And thank you so much, especially Witness 2 and David. And I think it is absolutely outrageous that academics now can't actually openly give statements revealing who they are in fear of the repercussions. So I applaud your courage for coming and telling us your stories. Thanks so much. Thanks, Chair.
Thanks, Senator Faruqi, and thank you so much all for coming in today. Unfortunately, we've run out of time, so I suspect a number of us will put some questions on notice for you and for the additional witnesses that we weren't able to hear from, unfortunately. I'd also like to thank very much David and Witness 2 for coming and telling your own story today. It's really valuable evidence to the committee. And thank the officials of the union as well. That concludes the evidence from the NTU today. I'd like to thank you very much, ask you if you would like to disconnect from the video conference, and I advise that we'll take a very short break and we'll return at promptly at 11:35. Thanks, everyone. Commence the committee proceedings, and I now welcome representatives from CAPAO and the La Trobe Casuals Network. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise witnesses that answers to any questions on notice should be sent to the Secretariat by 5:30 Wednesday, 9th of March. I invite you to make a brief opening statement should you wish to do so. And for the Hansard record, when you do speak, could you please state your name first and the capacity in which you appear? Do you have an opening statement?
We do.
Okay. Could you state your name if you're delivering the opening statement, and then go ahead? Thank you.
Thank you very much. I am Dr. Siobhan Irving, and I'm here as a representative of CAPAO, Casualised Unemployed and Precarious University Workers. I am speaking today from the lands of the Watamatical people of the Darug Nation, lands we acknowledge are not and have not been ceded. We thank the committee for the opportunity to speak today. As is now commonly accepted, underpayment of university casual staff is rife. When a number of us first testified to this committee a year ago, the extent of wage theft prompted Senator Sheldon to characterize the current system as the Uberization of Australia's universities. Since that time, reports of underpayment of university workers across the country have only increased. Indeed, as Dr. Kangere will explain, just yesterday, millions of dollars of underpayment were revealed at La Trobe University after a long campaign by casuals there. But rather than focusing on the extent of underpayment in this statement, we wish to reflect on two other things. First, the long drawn-out process casual staff must currently undergo in order to reveal underpayments, often for little gain. Second, we wish to propose solutions that tackle the root causes of underpayment and ensure it never happens again. As an illustration of the Kafkaesque process casuals across Australia must go through to reveal underpayment, we will briefly step through the long-standing campaign by casuals at the University of Sydney. At the beginning of the pandemic, many casuals reported fearing for their jobs, reports that sadly proved to be true. In response, the University of Sydney Casuals Network organized a survey of 159 casual staff in one faculty. This survey found that 82% of casual staff reported doing work for which they were not paid. When this finding was put to the university by the student newspaper, a university spokesperson declined to comment. To gather more evidence, the Casuals Network then organized an audit of the actual hours worked by casuals compared to that for which they were paid. This audit found over 90% of participating casuals performed unpaid work during semester 2 of 2020. In response, a spokesperson for the University of Sydney stated that beyond this report, we are not currently aware of any other data or evidence to suggest our academic staff are frequently working hours beyond what they are contracted to do. Further, following further campaigning, university managers did their own audit of casual underpayment, seemingly to avoid having to do one jointly with the Casuals Network and the NTEU. Unsurprisingly, this self-audit was used by managers to exonerate themselves and argue that there was no evidence of underpayment. However, when details of the self-audit were released, it was revealed that it was based on casual timesheets where casually employed staff were not in fact allowed to submit the actual hours that they worked, only the hours predetermined by managers. Towards the end of last year, when Casuals Network and the NTEU put together even more detailed lists of breaches of the enterprise agreement, managers eventually acknowledged privately that some casual staff may not be being paid for all of their work. But they also argued that this was the fault of casual staff themselves. It was argued that casual staff could have claimed for all their hours that were worked the whole time, they just chose not to. This was, of course, patently false.
Ms. Irving,
Yes?
sorry to just jump in there. We do have a copy of your opening statement, which is very comprehensive, and we thank you for it. So we are able to refer to it. And I think in the interest of time, I might go to Senator Faruqi to start with some questions, which I'm sure will also go to the remainder of your statement, which we very much thank you for. Dr. Faruqi, Senator Faruqi.
Thanks, Chair, and thank you, Dr. Irving, and everyone else who, some of you we've heard from many times before, and for all your hard work, which you shouldn't really have to do. So if I could just ask, you know, in the year that we last heard from you, apart from more and more universities admitting to or being forced to admit to underpayments and having to kind of repay their staff the millions of dollars that were owed, what has changed? Do you think universities are starting to change their tune in terms of addressing the systemic issues, or you see little change?
Happy to take this one. I think we can be pretty confident in saying that there has been very little change. I should say, my name is Yagan Doran. I'm an ongoing staff member from the Australian Catholic University and a long-term, recently finished long-term casual staff member at multiple universities, and I'm here on behalf of CAPOW. We can say pretty safely that very little has changed. At best, we have seen some back payments, but those have been following very, very long campaigns by casual staff themselves in relation to Casuals Networks and the NTU. Campaigns that have essentially kind of, we can characterise as a bit of a whack-a-mole, where they pop up many, many, many times, and it's very rarely that universities will admit to anything. And then if they do, there's little sense in which there'll be any systemic change after that. It just keeps happening.
Mm. And you have suggested in your statement, you've said that there is little incentive for university managers to change their practices. Could you elaborate a little bit on that and tell us what sort of incentives would you like for university managers to change their tune? Because we have heard also that often the blame is put, as you said, Dr. Irving, not just on casuals, but they're kind of line managers as well, who sometimes, I think it's in Dr. Kenjere's statement, that they are trying their best to make sure that people who report to them are not overworked and underpaid. So what sort of incentives are you thinking of?
I think one of the major things at this stage is that the current focus on kind of post hoc compliance, where underpayment occurs and then it's expected that casuals need to campaign for back pay, and that's basically the extent of the incentive for universities to not have essentially a PR issue in the media. It simply isn't working at all. There's no incentive in the sense that at worst, they just have to pay the wages that they would have already had to pay. At best, they just get away with it. So our incentives that we suggest are much firmer, whereby, for example, there be a very, very definite set of benchmarks at both federal level and state level of ongoing proportions of ongoing work, so that the root cause of underpayment, which is the extensive casualisation, as Dr. Barnes mentioned, 2/3 are in insecure work, 2/3 of staff are in insecure work. That's the root of underpayment. If we make sure there are explicit benchmarks that tie increases in funding at the federal level and make sure that they need to be maintained in order to maintain university status at the state level, that immediately gives universities incentive to employ staff permanently, and in doing so undercut much of the current basis of wage theft.
If I could just jump in there, Dr. Faruqi, I think that the current way of looking at wage theft as some kind of accident or anomaly that occurs occasionally when some kind of administrative error has taken place is really false and needs to be rejected. This is a comprehensive part of eroding the working conditions of workers at Australian universities, and it is part of a suite of problems which also extend to the overwork and exploitation of permanent and fixed term staff who don't necessarily resonate with an underpayment claim, but who are also experiencing these erosions of their working conditions. So I think that that's a really crucial distinction to make, that this isn't kind of an accident or a glitch that can be kind of fixed in a post hoc incidental measure.
And yet universities, from what we've been hearing, just keep saying that it can be, because it's an error here and an accident there. But it's quite clear from what I've been hearing for the last 2 years that that is exactly not the case. We heard from 2 witnesses this morning, casual academics, who were fearful of revealing their true identities and their names. Is that something that you are aware of generally in universities? And I know, Dr. Kenjere, that you've referred to, a survey that you did where 49% of the respondents said they would fear repercussions. Is that something that's kind of the norm in universities now, that academic staff are fearful of reporting that they're not being paid their due?
Yeah, absolutely. So I put that statistic in there because I think it really captures how profoundly normalised this practice has been. I've been testifying to the Fair Work Ombudsman around underpayments at La Trobe University, and they keep asking me, so did have you said that this is wrong? And I've been trying to explain to them how profoundly baked in this practice is. And I thought that statistic there, that 1 in 4 casual workers that we surveyed at La Trobe University, only 1 in 4 felt that it would be safe simply for them to raise the question of being paid fairly for their work, not to demand it, certainly not to come into a national setting and testify to the fact that that hasn't been occurring, but just to raise in a meeting, hey, this marking is actually taking me a lot longer than what you're paying me for. Would it be okay if I actually claimed for the hours that I've actually worked? So that gives a sense of the normality and also of the fear. And I would say that, it's been so beautiful to see these really powerful victories that rank and file casuals networks have delivered at all these different universities. But it is also really important to remember that this has come at a cost. Every single university that we have seen a big win for workers, we have also seen specific rank and file casual activists targeted personally. And that is a cost that is baked into this post hoc way of dealing with this pressing issue. So thanks for raising that, Dr. Faruqi.
Thank you for responding to that so honestly. If I could go to you, Dr. Yagan, for some specific questions at Sydney Uni, because you have been you're born witness to a lot of the wage theft claims over there. In October, I'm aware that a group of Sydney University casual staff in the NTU lodged a claim of unpaid wages of around $2 million last October. Is there any update that you have on that?
Thank you, Senator. I think the first thing I should clarify is that I no longer work at the University of Sydney, so if there's been any change in the last month or two, I can't necessarily say. The updates that we received toward the end of last year, essentially the University of Sydney Casual Network in conjunction with the NTU gave much more specific breaches of the enterprise agreement. The response was essentially that, firstly, the university disagrees that there are breaches, despite some of them being, from our perspective, quite black letter, clear breaches. And secondly, when there were staff that were being underpaid, in fact, that was the casuals' own faults, because at all times, casuals could have claimed for all the hours they worked, they just didn't. The effect of this was essentially, although it was patently false, the effect of this was essentially putting the onus back onto individual casuals to gather evidence to show that no, on the timesheets it says you cannot claim all your hours. When we do claim hours, we get our timesheets rejected. The university's managers would have known this, or at least if they didn't know this, they didn't work too hard to find out. But the effect of these things is putting work back onto the casuals, many of whom over time lose their jobs or leave the university. And so that kind of campaign starts to falter and has to come back up again. I don't know whether there's been any changes in the last 2 months, but I can contact the casuals currently at Sydney University and let you know on notice if need be.
Thank you. So as far as you know, 2 months ago, there was no movement on that $2 million claim.
As far as I'm aware,
Mr. Nunkom, if I could go to you, because I understand that you have a bit more knowledge and experience of the effects of wage theft on regional universities. If you could tell us a little bit about that, because we have heard again and again both the personal impact, which is just horrific and really unbearable on individual staff, but also broadly on education and universities and students.
Yeah, thank you, Senator. I can only speak for Federation University, of which I'm a PhD student at the moment. So, just commenting also on being fearful to disclose one's name to panels like this as well. I'm kind of in a unique position because I've got a little bit of a bubble of protection because I'm currently doing the PhD. I'm sure others that are thrown out into the workforce don't have or don't feel the same sorts of security to comment on these issues. But I'm also an employee of Federation University as well and have taught casualised work for a number of years now. One of the things I want to comment on is I think regional universities are actually attempting to ride out the storm of these wage theft reports and inquiries by kind of pretending that they're innocent and delaying any investigation into wage theft. I just want to direct the panel to just last year in October, we had the Fair Work Ombudsman's Sarah Parker commenting in a joint panel with TEXA that, you know, universities, all universities should be auditing their pay structures now, not when the underpayments are discovered. Because, in her words, these issues are common and systemic. You know, and regional unis certainly have not been paid, university workers certainly have not been paid for things like lecture attendance, issues around academic judgment rates, even things like ensuring teaching quality by being paid to attend marking moderation meetings, right? Those things aren't paid for, and these are the kinds of things that are appearing in major university wage theft reports. It's much like a mirror reflection of what's happening in regional unis. Yeah, and the other issue with regional unis as well is because they don't get the same amount of press as major metro unis and they don't have the same level of resources, whether from the labour that casual networks put in, union reps, those sorts of things. It takes quite a long time for wage theft inquiries to kind of trickle down to regional unis, even though the issues are exactly the same. You know, so yeah, the longer the delays, the more acute they are, I think, for regional university workers.
And is it still the expectation, and this is an overall question for anyone to answer, that staff come forward with, you know, with their kind of understanding of how they're being underpaid, that staff have to make claims rather than the universities? Or I think in one of your recommendations, you have suggested that there be an independent audit, regular independent audit of how casuals, you know, are being paid. But that's obviously not the case now. Are staff still expected to come forward with their own underpayment claims?
That's my understanding at the moment. A lot of even my work with the union has sort of devolves into a lot of casework, individualised casework, when individual employees approach with individualised grievances, even though a lot of the underpayments would actually apply to a whole bunch of workers. The other aspect as well, in terms of this riding out the storm notion that I was commenting on earlier, is that FWO has already written to all universities requesting them to do audits. Yet at my institution of Fed Uni, we've not heard anything about these communications with Fair Work. So we don't know when or if an audit is going to happen. And there seems to be no stick to push universities to start to commence these audits without significant pressure and risk put back on workers to speak out.
So I know that Senator Scarr has some questions, but I'll just ask one more, and that's about piece rates. That's something that we have heard again and again in this inquiry and the job security inquiry, how they are used to underpay staff. And universities keep telling us, and we've heard a number of universities said that they no longer use piece rates, or they're looking at, you know, not using piece rates. Is that your experience, that that has become the norm now, or that universities are getting rid of piece rates?
I'd like to speak to that, Senator Faruqi, if that's okay. At my university, at Macquarie, I've been quite active with our local branch of the NTU in trying to negotiate, or I should say renegotiate, piece rates with university management. And unfortunately, while we've been told that management is in principle agreeing to do this, they've told us, oh, well, yeah, that's a good idea, we should look into that. Every time we raise it, we get the same response and nothing actually ever happens. The piece rates remain the same. In fact, our work is being intensified because of budget cuts due to COVID. And in many cases, our piece rates actually end up needing to cover an awful lot more, is getting packed into this rolled up rate that we're being paid, and things that we're just expected to sort of add on. So for example, like increased email contact with students who might have questions about their grades. We may be paid to mark, 3 papers an hour, or 3,000 words, or sorry, that would be my dream, 3,000 words an hour. We may be paid to be to mark 4,000 words per hour, but we're not paid for the interaction with the students who maybe ask more questions. Can I have more feedback? Can I, perhaps challenge this grade? We're not really paid for all of the time that consumes. And that is time that's actually increased much more since COVID and online teaching and students having less face-to-face time with us in the classroom. These are all subtle points where our work's intensified and piece rates don't cover it. And unfortunately, management is not willing to discuss this, or it hasn't been at least up until this point.
Chair, I do have a couple of questions, but I'll come back if there's time at the end.
Okay, thanks, Senator Faruqi. Senator Scarr.
Thank you, Chair, and thank you for everyone appearing today. Thinking about and reflecting on these issues, it seems to me that some of them come down to basic corporate values, and it should be a corporate value or organisational value at our universities that everyone is treated with respect, everyone's treated with integrity, and everyone is valued. Do you think that the practices which you've been impacted by would indicate that those values are not being adhered to by our universities?
Thank you, Senator. And yes, we would agree that those values should be absolutely standard at universities, as in all workplaces. Whether or not they're being adhered to, no, very, very simply. The overarching thrust of policy when it comes to casual staff and staff in general at universities is one of finances. How much work can we get out for how little money we can spend? And we've seen this through COVID, where despite in many areas of universities and in many universities themselves, student numbers have increased, and with them student fees, there have been mass redundancies and laying off of casuals. The overarching value that drives the university is to pay as little as possible for as much work as they can. And one of the reasons this occurs is because most of the senior managers are so high above any day-to-day worker that does face-to-face classes or researchers that they likely haven't met one outside of an ad hoc meeting here or there for years. Many of the senior managers would likely have never taught when PowerPoint began to exist. They still talk as if we are in universities of yesteryear where we didn't have mass student numbers and we didn't have to do as much preparation when, as former interim Vice-Chancellor Stephen Garton said in a Senate inquiry, whereas as a lecturer you could just walk in and deliver your lecture. Now, I doubt that you could probably do that 30 years ago while doing a good lecture, but you definitely cannot do that now. And that seems to be the attitude from senior managers that...
And this is, we don't have much time, but from my perspective, there is a financial aspect to it. I mean, they have to manage a budget, right? And they're not Robinson Crusoe in that regard. Every business in Australia has to manage a budget. Every state-owned enterprise
Universities, though, are not businesses, Senator Scarr. Highlight they're not businesses. They're public.
No, fair comment, Senator Faruqi, but they do have a budget to manage. So there's income and receipts they need to manage. But from my perspective, that's no excuse in terms of treating employees with respect and integrity, whether or not they're casual, full-time or part-time. That obligation should still be there. So it causes me concern when in one of the submissions from the universities it said, if the university becomes aware, right, of X, Y, Z, as if, well, it's happening at the university. It's not a question of you becoming aware. You need to proactively find out what is actually happening with your employees. And in fact, I would have thought there's a moral obligation, especially with respect to casual employees, to make sure that through their love of the institution and the love of the work they're doing, that they don't compromise themselves and their own well-being by doing too much. And so there's a moral dimension to this in terms of the senior management, the senior leadership of the organisation, actually having a moral obligation, in my view, to actually do a deep dive into the experience of the casual staff and see what's actually happening. And whether or not people are self-censoring their timesheets and not actually claiming that which they should be claiming. So to me, this connotes a failure of leadership. I'm just interested in your views with respect to that.
Yeah, thanks, Senator. And just taking Dr. Faruqi's point that universities aren't corporations, absolutely agree with that. But if we do take that corporate value of respect, the other kind of figure who's really not being respected here is that of the student. What does it communicate to our students when the people who are teaching them are expected to absorb the materials conducted in the lecture by osmosis? When the people who are marking their work are supposed to thoughtfully mark thousands of words overnight. This constitutes a deep disrespect to those students whose learning conditions are our working conditions and whose learning conditions are therefore eroded by this practice. I really take your point about this, Senator, as this being a failure of leadership. As Dr. Barnes from the NTEU mentioned earlier, if universities really want to address wage theft, they have adequate information to do so. This is one of the reasons why CAPOW has requested as one of our policy initiatives moving forward is a regular independent audit of the number of hours that casual workers are actually spending. We know that universities cannot be trusted to self-regulate on this question, and so we are asking the government to actually step in and to create that external independent audit in order that we can really have the figures to progress forwards on this. Because you're right, this has been a failure of leadership and it will continue without intervention.
Okay, thank you, Chair.
Thank you very much, Senator Scarr, Senator Faruqi, and thank you very much to all of the representatives from CAPOW and the La Trobe Casuals Network. Your evidence has been hugely valuable to our inquiry and we very much appreciate your time. And I'd invite you now to disconnect from the video conference with our thanks. And I now welcome representatives from the Monash Casuals Network and the University of Melbourne Casuals Network. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones and please ensure your microphone is set to mute when you are not speaking. I'd also like to advise witnesses that answers to any questions on notice should be sent to Secretariat by 5:30 Wednesday, 9 March. I invite you to make a brief opening statement should you wish to do so. And for the Hansard record, could you please state your name and the capacity in which you appear?
Hello, Senators. Can you hear me okay? My name is Dr. Giles Filkey. I'm the representative, one of the representatives today of the Monash Casuals Network, and I'd like to just read our opening statement, if that's okay with you.
Yes, please go ahead. Thank you.
So I'd like to acknowledge that we're calling in from the Wurundjeri Woiwurrung lands of the Kulin Nation here in Melbourne, to pay our respects to elders past and present, and to acknowledge that sovereignty over this land was never ceded. We, the Monash Casuals Network, recommend the following to the Senate Economics Committee inquiry into unlawful underpayments. Our experience as casualised academic and professional employees of Monash University is that the casualisation of academic and professional roles at the university leads to wage theft. We have documented evidence of this concerning reality across the university here, which we have included as testimony in the submission that we would like to be tabled by the committee. After hearing some of the most marginalised and worked over employees of Monash University over the past 2 years, we at the Monash Casuals Network have forced the university to now admit to systematic underpayments to wage theft that would otherwise have been left unaddressed, and which had seen employees of the university taking home sometimes only 1/3 of the pay packet that they were owed under our current enterprise agreement. These are breaches to the current and former employment agreements that the university has now admitted to. However, we believe they have only admitted to part of the problem by strategically admitting to only a fraction of the real wage theft that we have heard of and have experienced. This has provided a smokescreen for the practices which continue unaddressed here at Monash University. So we believe that the material basis of wage theft is the casualisation of our work, and that concrete steps still need to be taken to address this at Monash and in the Australian higher education system more generally. And so I have a couple of recommendations that I have tabled here, and if I have the chance, I'd like to read them out now. I'll just be 1 more minute.
Sure.
So, yes?
Yes, that's okay. Please proceed.
That the employer pay casual employees for all the hours worked at a reasonable rate, one that properly values the work we do, that piece rates are unacceptable and unpaid work is unacceptable, that the employer supports casual employees in the complexity of their work. Some of us have trained for 4 years to deliver the highest quality of education and professional standards to the public institutions where we work. So thirdly, casual work, we believe, leads to worse education for students by creating downward pressure on quality. As you've heard today already, teachers either work to the time they are paid and the educational quality suffers, or work unpaid. The university is incentivised to churn through untrained people with little to no experience and pay them low rates to do so. That will impact the careers that students take. The practice of long-term casualisation must end. And so we recommend a formal compensation process for casualised staff at Monash University be established for people who have been had their wages stolen by the university and by universities around the country. And we ask that it be independent of Monash University and administered federally for the entire sector, with no statute of limitations for wage theft claims by current or formerly casualised staff. Thank you, Senators, for your time today, and we look forward to answering your questions.
Okay, thank you, Dr. Fielke. Dr. Singer, we've got both a submission and an opening statement from you for the University of Melbourne Casuals Network, but did you want to make just a couple of opening statements and then I'll open it up to Senator Faruqi for questions?
Yeah, thank you very much for having me here. I would like to read out my opening statement in full, if that's possible.
Let's see how we go. I might cut you off, but okay. Please have a go. Thanks.
I'll pick out the best bits.
Thank you.
Thank you so much for having me here today and for listening to what I have to say. So just briefly, I started teaching as a casual academic in 2014. And over the 7 years that I held that position, I developed and refined my teaching and my research. I provided at that time the university with 295 hours of marking that at the time went unpaid. And after a 2-year campaign, I was one of over 600 University of Melbourne tutors who finally received back pay on this wage theft. Throughout my 7 years as a casual academic, I've received outstanding feedback from students each semester. And in 2019, I was recognised by the University of Melbourne for my contribution to higher education with an Excellence in Teaching Award. And I'm pointing this out just to say that I do not just love teaching at the university level, I'm also very good at it. As a casual academic, I remember sitting in a meeting where management suggested paying casual staff with gift vouchers for giving lectures instead of paying with actual money, loadings, leave entitlements, and superannuation. I contested this at the time because I know I can't pay rent, pay for transport, for medical bills with gift cards. Senior academics pushed back against this too, and still it went ahead. This is how casual and insecurely employed academics are treated when we bring our professionalism and our expertise onto campus and into the classroom. And I wonder if anyone in this room would consider a gift card appropriate payment for the work that they are doing. The university systems of workload calculation are so opaque and, in my experience, so inconsistent that it feels impossible at times to articulate how or why your pay does not reflect the time, experience, skills, and knowledge you have put into a week or a semester or a year of teaching and preparing to teach. It's the that the university systematically underpays and overworks academics. And being chronically underpaid by the university has meant that for years I have pieced together a living from a perverse mosaic of installment payments. While working as a casual academic, I always had to hold a second job to pay my bills and make ends meet because the university was not paying me properly. At the end of 2020, at around the same time the university was paying hundreds of casual academics millions of dollars in back pay for wage theft, I was offered a new position, a 2-year fixed-term contract that was supposed to provide employment stability and professional development, and I believed I would finally receive fair remuneration for my work. My position description requires me to be a committed and engaged educator who teaches to the highest standard. However, after 1 year in this new role, I can say that the university's opaque and inconsistent workload calculations don't allow still for the actual time it takes to prepare and deliver high quality teaching and provide students with the consultation that they need. And I'm very sorry to say that I have never worked more for less. I know that I am not alone when I say that I have been and am still in an impossible situation. Either I undertake work for free, which amounts to wage theft, or my students receive a substandard education, which amounts to education theft. I will not compromise on what I offer to students. The university relies on this, so for now, wage theft continues. It does not feel controversial to me to say that the university is operating through a culture of theft, that this theft happens in many ways, too many ways for me to outline properly in 5 minutes, but I do want to leave you with one example of workload pay dispute or discrepancy that I've recently been negotiating. We casual and insecure workers are given 3 hours only to prepare for a 1-hour lecture. When I ask other highly experienced academics how long it takes them to develop a 1-hour lecture, I am told something similar each time. A lecture is a culmination of all your years of research and at least a day and a half of solid writing time, not 3 hours, 10. Thank you very much.
Thank you so much, Dr. Singer. I'm glad I didn't cut you off there. That was a really powerful statement. Thank you. And I'll go to Senator Faruqi for questions.
Thank you, Chair, and thank you both for your statements. And yeah, I mean, it's so disheartening to hear the same story over and over for some time now. But, you know, thank you so much for telling us like it is. And I see that we have some witnesses online at the moment who haven't revealed their identities. And I just wanted to ask, that is the fear of repercussions if you say the things that you are saying now, is that something that staff are experiencing at the universities that you are at?
I believe it is. I had to do a lot of critical thinking around the question of whether I revealed my identity today, but I'm in a position where I can make that decision to reveal my identity. And also, because I feel that way, I want to be there to support those people who cannot, because I do not believe in a world where we have to hide our identities in order to tell the truth. But I do know that when you speak up, when you make a racket, you do feel as if you are under a microscope, and you do feel as if there is a special kind of attention being paid to you, and it's not positive attention in my experience.
If I could go to you, Dr. Fielke, you referred to a strategic admission of only part of the wage theft by Monash management. So how much is missing, and have you been able to quantify that?
Thank you, Senator, for the question. We have seen the university at Monash admit to underpayments to wage theft here. I think about $8 million they admitted to last year in 2021. They did their own audit, and they found these discrepancies in a way that was similar to what you heard already from Dr. Kanjere, speaking about the time cards that are being audited here, where many times casualised workers are not actually able to submit the hours that they've actually worked. And so what we're doing is trying to make that case at the university with the HR department there in workplace relations, since they've announced the results of their audit and the back pay that they've begun. But unfortunately, we haven't been able to meet with them. They haven't been willing to meet with casualised representatives from the National Tertiary Education Union branch here, for example, from the Monash Casuals Network, of which we're a part. But I would let others hear you referring to some of the other people who are in this room who might want to speak to that point too, if that's okay. I think I can see witness 5 with their hand up.
Yeah, definitely. But I find it preposterous that isn't it the vast majority of wage theft being done, the victims of that or the targets of that are casual employees, and yet university managements refuse to speak to them. So I might go to witness 5 if you'd like to respond to that.
Thanks. So I'm witness 5, and I was a sessional academic at Monash over a 5-year period, and I'm one of the people who received like a large lump sum of back pay from this underpayment of $8.4 million that you've heard about in the news. But speaking across the network, I think I'm actually one of the lucky ones because of this very narrow definition of who was an affected staff member that, as we just heard about, was based on like the timesheet entry. So to give you a sense of that, this back pay amount was tens of thousands of dollars, but according to my estimates, over the 5-year period, that's less than a third of what I should be paid from this, from sort of the casual network's definition of wage theft. But, other people who have experienced, not being paid for marking, which is a huge concern in many schools across the university, that's something that doesn't fit into this narrow definition. So I think when we think about or try and estimate sort of the costs involved, just from my experience in the network, I think that this $8.4 million is, just a small fraction of what people are owed. So, these unpaid marking in particular needs to be investigated, and we're not satisfied at all with this narrow definition. And also Monash is refusing to even call it wage theft. They are calling it a mistake, which we don't accept.
Yeah, and which I don't accept either. It's rife and it's rampant. Do you think this strategic admission that's happening, is it happening across campuses? It seems it's happening at Monash. And is this kind of a tactic that the universities are using? And really, what are the implications of this?
I might speak to that. So I'm appearing pseudonymously as Greg today. I am a member of the Monash Casuals Network and worked with Witness 5 and others appearing on the call on the casuals-led investigation into wage theft at Monash University. And I worked at Monash for several years teaching research methods and statistics. So I might just speak to the actual methodology by the university here, which was specifically to identify in the comments section of it whether the word tutorial was matched with a time code that was submitted that was not a tutorial. So the most common way wage theft occurs at Monash University is managers are coercing staff into listing their work, teaching the youth of our nation important skills as an other required activity. So this speaks to the perversion and warped idea of the university by the management, whereby the core function of a university, which is teaching, is being described as an other required activity. So that leads one to ask, what is the core activity that is a university's function if teaching is an other activity? How the university admitted to wage theft, quote unquote, they, as witness 5 mentioned, term it a mistake, is if someone submitted a task as other required activity and wrote in the comment section, tutorial 1 for this, it was picked up as a mistake, right? So what that means is they're only admitting to situations where they failed to properly coerce the staff into hiding their own wage theft. So this 8.6 million is a disgrace. It's a fraction of what staff are owed. Thank you.
It's the tip of the iceberg, as many have already suggested. Could I move to the University of Melbourne Casuals Network? In its recent submission to the Job Security Inquiry, on which both Senator Walsh and I sit as well, which is another Senate inquiry that's going on, the University of Melbourne stated, the university has made public its commitment to addressing the issues of insecure employment and casualisation, and the Vice-Chancellor and Provost have been personally conveyed a conviction that this provides neither, have both personally conveyed a conviction that this provides neither a sustainable nor a desirable model for the future of the university. So could I ask you, in your experience, is there any evidence that the current model is not desirable, and are you seeing any changes at the university?
Thanks very much for that question. It's really hard to answer, actually, because there are a range of measures that the university says it is bringing in. But when you drill down into the detail, it becomes clear over time that actually many of these practices that result in wage theft and insecurity are actually being shoved into these new positions. So, for example, in the situation that I can best talk to is my own. So coming into a fixed term contract, I honestly thought I was going to get and fair remuneration. Because I have been in a position to be negotiating my workload semester by semester, because the workload calculations, which I've said are opaque and feel very inconsistent, mean that I'm constantly being asked to do far more than I'm being paid. I'm in a position where my colleagues and I have been negotiating what we are doing semester to semester, which creates an enormous amount of instability because I don't know where my wages will be for the coming semester or the coming year. And also I don't know if I have to or can take on more work to make up the shortfall that may or may not occur because of the amount of work that I'm given. So it's a very long answer to say I really don't think that it is being addressed. I think that the problems are being pushed into the new roles that the university are holding up and saying, look, this is what we're creating in order to address the problem. And that's what makes me feel like it's not controversial to say that the university continues to operate through a culture of theft, whether that's wage theft, education theft, or in the case of some fixed term positions that are teaching only, credentials theft, because we're being asked to account for our research and the university are putting us forward sort of online as researchers who are active. And of course, we need to be active researchers because we cannot be employed as level B. We cannot progress through into more stable employment if we do not have really strong research portfolios. So that research, which is going unpaid for, is being used by the university to say to students, look, we have industry professionals, we have critically acclaimed people who conduct the teaching for us. That is absolutely true. That is what we are, but not because we're being supported in that work. So there are so many ways in which the university is actually not addressing the problem.
At the same inquiry that they appeared in earlier this month, Dr. Singer, the university management said that they are working to remove the use of piece rates altogether as soon as they become aware of the use of piece rates. And then they added, if we become aware of this occurring, we act quickly to remedy it. I mean, is this really good enough for universities to wait for staff to raise these issues? We have heard earlier that there should be an independent audit of universities as well in terms of their practices towards casual staff. And do you think that there is a serious attempt to abolish piece rates at your university?
I honestly don't know. Because I am in the mix of negotiating my own workload semester to semester and supporting colleagues who are also doing that as well, I don't have that kind of a broad picture. So that might be something that I take on notice and the union can sort of respond to. But as somebody with their feet on the ground, it's not okay, it's not fast enough, and it has resulted in people, workers, casual academics, spending most of their time pre-semester actually trying to figure out how much they will or won't be paid, how much work they will or will not have. And that means that pre-semester time where you could actually be, finessing your skills as a teacher, thinking about pedagogy, doing the research that you will carry into the classroom, you actually spend in lengthy and complex negotiations with an institution that feels utterly immovable.
Democracy and governance issues have been raised by casuals in your submission, where the issue of, that insecure workers are not represented on any decision-making bodies has been raised as an issue. So I just want to hear from you what kind of a bit of more of an elaboration of what are the issues with, when there are so many, 70% on average at universities, staff that are casual and in insecure work, and them not being represented in university decision-making bodies. What impacts does that have?
Giles, I think I'll let you take that one.
Yeah, thank you, Senator, and thanks, Hayley. I would just like to mention that I'm a former colleague of Dr. Singer at the University of Melbourne, where in answer to your questions earlier, Senator Faruqi, the ramifications of speaking up and using your name meant that this year, after 7 years, I no longer have any work at the University of Melbourne. I would say that the representation that we've been asking for casuals at the University of Melbourne Casuals Network, where I was previously, but also at the Monash Casuals Network and the NTU branch at Monash University, as I mentioned earlier, has been a repeated call for representation at a local level, at school levels, where I work in the Monash Art Design and Architecture faculty, for example, at the Fine Arts Department. I've asked for casual representation in management meetings and decision-making there repeatedly. We've asked to be able to meet casual representatives to be able to meet with the HR and workplace relations teams to describe and explain the realities that we're facing and the experiences we're having. And repeatedly we're told that we're not senior enough, or we're not actually able to meet with management because casual employees, as you I'm sure understand, are treated as a separate class of employee. Therefore, they're kept at arm's length and are never invited to meetings or to discussions within the schools or within the larger university management structures that directly affect the work, and would also, as I'm sure you can appreciate, perhaps help to stem some of the horrible outcomes and realities that you've been hearing and have been submitted here at the committee so far. So that's a real problem for us, is representation.
So you're overworked, you're underpaid, and you have no representation where you can, push through your issues and have them addressed. Universities have to be rebuilt, is all I have to say, on democracy and equity. So I know Senator Walsh that Senator Scarr has some questions, so I'll happy to go to him and then come back if there's time.
Yeah, thank you very much, Senator Faruqi. And yes, I'll go to you now, Senator Scarr.
Thank you, Chair, and thank you, Senator Faruqi. Dr. Singer, I just want to drill down into some of these practices so I really get an appreciation of them, right? So where were you offered gift cards to perform work?
So I have not been offered a gift card to perform work at the University of Melbourne. My experience with gift cards was through a different university where I was told, I was invited as a specialist to sit on a PhD review panel, and I was told that I would either be paid with a gift card or could do it for free or would not do it at all. I want to use my skills and I want to contribute to the academy. So in that instance, I took up the possibility of being paid with a gift card. What I do know and have confirmed with colleagues last night is that gift cards are still there for people to take up as an option. I put that in inverted commas because the people who are told that paying with gift cards is a possibility are often not told that that is an option. They think that that is the only mode that they can pay. Guest lecturers or industry professionals who come in to talk to students. So the question of gift cards is really quite enormous. The thing that I can report on with, from my personal experience is sitting in on a meeting with management where they had contestation from myself and senior academics, and they sat there and could not believe that there would be a problem with paying professionals, highly specialised people with a gift card. And I don't know, but it's my understanding, or it's a question that needs to be investigated. Does a gift card have superannuation attached to it?
Dr. Singer, you don't have to, it's unacceptable from my perspective, and I'll be putting it to the universities on a number of levels. On a number of levels, it's unacceptable. Which university was it? Do you feel comfortable saying which university it was that offered the gift cards?
I don't feel comfortable saying which
university. That's okay. I'll put it to each of them. And then, Greg, I wanted to ask you some questions. So I really want to drill down into this practice in relation to other academic activities, right? So as I understand it, there's a substantial concern that work which in the lingo I'd remember from my university days would probably be described as a tutorial, is being typed as other academic work or something else which attracts a lower rate, so that when casual employees are filling out their timesheets, there's pressure to classify work as other academic work as opposed to tutorials, which it probably is. And I would have hoped that our universities are teaching substance over form, to be frank, and that should apply to the timesheets as well as critical thinking. So can you just drill down, just walk me through how that phenomenon occurs, what overt or covert pressures leading to it, and the ramifications, because I really want to appreciate how that is happening in practice, so I can put some questions to the universities.
Yeah, so I can definitely speak to that. And I think you hit the nail on the head with speaking to Lane.
You're just breaking up a little bit, Greg.
Yeah, Greg, I think, Greg, if you turn your video off entirely and go again.
So try again, Greg, without the video.
It's a right. So if the am I back?
No, sorry. Can you try again? You've got the video off, which helps in our experience. But if try again.
And if other witnesses and senators would just turn their videos off for a moment as well, we'll see how we go.
Yeah, you're back. And I note some of the other witnesses, I think, have a contribution to make in this regard, because it's an important point from my perspective to understand. So if you can,
so
I
can
got
definitely
it walks
speak to
like
that
a duck,
question.
it talks like a duck. Yeah.
Yes, exactly. You hit the nail on the head with that. It's the position of the MCN that if it walks like a duck, it's a duck. And so we've had many casuals report to our union and the Casuals Network that essentially a process of changing the language around teaching while keeping either the form and the structure and the content the same is occurring, such that a tutorial will be renamed a workshop, your teaching class, any number of words, just to elide the fact that it's a tutorial, therefore allowing the management to coerce staff into reporting their work as an other required activity. So what that means is that staff are not paid at all for their preparation. So if I taught a 1 hour tutorial, I would get paid. Seems fair. If you are paid according to the 1 hour other required activity rate, you will be leaving with just $45 at the end of the day. So that's what we mean by huge underpayment, such that people are being left with only 1/3 of the wage that they are owed. In extreme cases, so I was in contact a lot with engineering faculties, which I'll mention are composed of a lot of teachers from diverse backgrounds, a lot of immigrants, quite vulnerable people. And we had a workplace meeting in those schools, and we were told that the staff there had no idea that anyone in the university was being paid according to the tutorial rate. So it goes beyond even just, oh, can you have a discussion with your management about this, where you're actually not even aware that you can be paid properly and your subjugation and domination is the norm. And a lot of these people, in one of those cases, one of the people spoke out about this and were then not offered any work the semester after they spoke out. So it's a very complex issue. It occurs in different ways in different schools. And that's because the whole process of casualisation is the material basis of this underpayment, and it allows for basically a wild, wild west scenario where each school is taking advantage of casuals in a different way. In my school, when I worked in a department I won't name, I was basically brought in front of HR and told there's no way you'll be paid according to the lecturing rate, even though I prepared 12 3-hour lectures in the pandemic from home, and I was paid at the other required activity rate. And this was just a blatant one-on-one Zoom call where I was told it's just not going to happen. You either won't work, we'll get someone else, or...
Okay, Greg, thank you. I want to give an opportunity to the other witnesses just to, I fully understand the point now, so I thank you. Witness 5.
Just quickly to add to that. So, yeah, it's funny, Senator, that you mentioned how you would think of classes when you were at university, because the schools that I teach in, the skills and the texts that we're teaching are maybe like at least 50 years old. So from my perspective, you know, each week the same amount of material that we deal with is the same as, like, you know, half a century ago. But I think, like, speaking to the point about casuals not being involved in sort of these top-down decisions, even over the 5-year period that I was teaching, there were directives to reduce the preparation time that we could get paid for to arrange these classes. So, you know, like I'm trying to say, it's the exact same amount of material that needs to be covered, and we're expected to, yeah, basically degrade the quality of the class that we're going to deliver by spending less time preparing.
So you're put in an impossible position where either you shortchange yourself or you shortchange your students.
Yeah, exactly. And I I always choose shortchanging myself, and then in order for my timesheets to get approved and I can get paid to pay bills and things like that, I have to abide by the predefined time constraints, even though that's not my reality. So yeah, I think it's really important that we've brought up today that yeah, there's this coercion to be submitting a description of the work you've done so that it will get accepted and you can be paid.
Yep. Andrew, I think you had something to contribute on this.
Thank you, Senator. So my testimony, which I believe is in regards to how definitions are being made in contractual agreements. For example, casuals are not being explicitly given definition in their contract of their duties and responsibilities. I was a casual that was paid at the other required activity rate for the past 4 years. I believe that the work I've done was teaching. I'm unsure of what the other required activity is, and I believe that we need to have proper definitions for the work that we do, in the sense that it's diverse. It varies from department to department. There are instances where people have worked outside business hours. There are instances where people have worked using substances which could be classified as dangerous substances, and they haven't been paid allowances or extra. There are instances where people are teaching across different years, and the complexity grows with each and every year, and the rate still stays the same. So what I would like to say is that we need proper definitions of the work that people do and proper rates for the work that people are doing there, not just being paid as a simple rate.
Okay. Giles, do you have something to add on this point?
Yes, Senator, thank you. Just quickly, I would say that one of the issues that we're finding in particular at Monash University is that the agreement, and I think the award, states that it's a 2-hour minimum per occasion for other required activity rates when that takes place. Even that 2-hour minimum, which is stated in the agreement at Monash, but also in the awards for the higher education sector, aren't being followed, because many, for example, this week I got an email saying we have a 45-minute meeting on Thursday. It's in person on campus. There'll be 14 casual staff members attending. That is not going to be paid at 2 hours unless, I have to remind the manager in charge that that's what those people should be getting for that meeting, for that occasion. And I think that that is systematic across the university, that people are being asked to submit times like 45 minutes, maybe an hour, for other required activity, which it states explicitly in our agreement that the minimum time per occasion is 2 hours when we...
So Giles, I would have thought, and I come back to these principles of respect and integrity in terms of our system, I would have thought if you attended that 45-minute meeting and you put in a timesheet for 45 minutes instead of 2 hours, that if you did that, the manager should actually go back to you and say, the timesheet's been incorrectly submitted, you should have claimed 2 hours instead of 45 minutes. Shouldn't that be the way the system works?
Well, I'm sure you'll be shocked to hear, Senator, that in fact, often when staff, casual staff do submit 2 hours for, say, a meeting that's only taken an hour or an hour and a half, they will receive emails saying you were overcharged for this time that you put in a time card. We only met for 45 minutes, we only met for an hour, and the time cards are rejected. So you'll see, as Witness 5 has stated, the only real way to ensure you're paid your wages on time in that 2 hour, say, two weekly cycle, is to do what you're told and not ask questions. Otherwise, you might end up not getting paid anything at all.
Okay. All right. I know I'm running out of time, Chair, so back to you. Oh, you're on mute, Chair.
Thank you, Senator Scarr. I think Dr. Singer may have had a contribution on that, and if she does, the committee would welcome it. Otherwise, I'll go back to Senator Faruqi.
I did just have a very brief contribution to what Giles has just said. Thank you very much for letting me speak again. I just wanted to point out that sometimes the people who are signing off on sort of Themis cards or timesheets are actually insecurely employed academics who actually have not had enough time or support to actually get their heads around the complex local operating rules that exist around those time blocks. So this is in no way to corrode anything that Giles has just said, but actually bolster this picture of the eroding of the possibility for people to do right by each other within this system. Coming back to your point, Senator Scarr, around sort of mutual respect and the obligations that we have to each other. So casualisation and insecure work is really affecting so many of the levels of worker. And that it is absolutely terrifying. And I have been in that position that Giles is talking about, when you put in a time card and it's rejected, and you know that you will not be able to pay your rent, or you do not know where your money is coming from for the next fortnight. It's a really scary proposition, and that is part of what's happening with a lot of the administrative tasks being pushed onto academics who are working as coordinators. Often it's unpaid, if they're employed casually, and there's not enough support there for those people to do the right thing by their tutors. That's not always the case, but it just should be noted.
And Dr. Singer, this comes back to leadership, doesn't it? I mean, if you're in a senior leadership position, a very well-paid senior executive position, or a vice-chancellor position at a university, one of the things you have to ensure is that you have people who've had the benefit of training, have access to resources to carry out their functions and role in a university. And if someone is considering that timesheet which you submit, and they don't know that it should be 2 hours, not 45 minutes, then that comes back to the leadership of the university, making sure that the right people with the right training are in the right positions.
Senator Scarr, thank you very much. I might just take that as a comment because I had given the call to Senator Faruqi, so I'll go to Senator Faruqi, but thank you very much, Dr. Singer and Senator Scarr.
Thanks, Chair. And just to that point that you were making, Dr. Singer, as well as, Senator Scarr, we've seen in a statement earlier today from another casual academic about this blame shifting to direct line managers of casual staff who are often, as you said, in insecure work themselves, and that senior management is kind of refusing to take responsibility and accountability for something that they are responsible and accountable for. Is that kind of what you were alluding to as well?
Absolutely. And something that is connected to that is that I'm not a union mastermind by any means, so I'm going to keep everything sort of within my experience. What appears to be happening from my position is that work that could and should be done by level B academics who are securely employed in ongoing contracts are actually being given out to insecurely employed level A academics who simply aren't being supported to work through the complexities of the administration that the university requires. So I would agree with the point that you're making there, Dr. Faruqi, that is what I've seen and that's what I've experienced.
Just coming back to you, Dr. Filkey, just wanted to confirm that you say you no longer have work at the University of Melbourne, partly because you believe it's because of you speaking out, because I do want to put that to the University of Melbourne, who unfortunately can't make it today, but I'm sure the committee would like to hear from them at the future hearing.
Yeah, thanks, Senator, for the question. Look, I have applied, as I always do at the beginning of the year, for teaching associate jobs or lecturing, session or lecturing jobs, also for fixed term engagements at the University of Melbourne in the department where I've worked for the last 7 years. And I think for the first time in that time, I have no work at the University of Melbourne this year. That's correct.
Thank you. And just my last question, and if a few of you could answer that, I'd be very happy. I mean, I guess it's a big question, but what has happened to universities in the last, let's say, 10, 15 years for casualization to become so rampant and for wage theft and casualization to become, the business models of universities as we hear again and again? Is there a link to the continuous funding cuts, funding freezes that government has basically done to universities to push them in a certain direction for their survival. Dr. Filkey, if I could go to you and then Dr. Heinrich.
Thank you, Senator. No, I was going to suggest that Dr. Heinrich might be a good person to ask. We haven't heard from them so far. Thank you.
Yep. Dr. Heinrich, if you could give us your insights into this. There's so much experience in the room at the moment.
Thank you, Senator. It's a big question, and I think one that over the last 10 years, it's got a lot worse. And I would just say that I'm speaking anonymously here. Last time I gave a comment to a journalist about conditions, casual workers in Monash, where I've taught for the last 7 years. I was a colleague in the hall shortly after said, "Oh, you're a marked man," as if the university and the management kept such rigorous documents of recent reports in the media and people speaking out. So there's so much fear around being able to talk about what's happening at Monash and elsewhere. Yeah, I think just to kind of speak just generally on your point, Senator, and then I'll say something about my own experience. But it's really a concerning situation where universities are recording profits, large profits. There's kind of never-ending new buildings that are being built, but we're kind of getting just my own kind of coordinators and for management more broadly, and talk that there's not enough money in the budget. That there's fee increases that are coming through, but there's never seems to be enough money to kind of properly teach or to kind of invest in teaching. So there's kind of what I'm feeling on the ground is that there's kind of a continuing level of squeezing happening, that we're told that we can't claim for particular things, there's not enough money in the budget, that the budget needs to be checked and so on. But really the point that Dr. Filkey made before about a lack of representation means it's really hard even as an experienced professional to get any insight about how it's actually working, both kind of at a management level, but also just kind of from the university itself. They often refuse to meet with casuals. And I just want to make another point about I think we've heard a lot about underpayment, misclassification, and wage theft, which are all very serious issues. But another central aspect to the business model that the universities are using is the kind of the precarity involved. So Dr. Filkey mentioned applying at the start of the year. Now you can apply well into January for a job that will start at the start of March. But often these are courses that we've taught year in, year out. I've taught the same course or similar courses for over 5 years. We're only paid for a very brief part of the year. So our contracts expire and we're kind of left in the lurch. We're supposed to kind of keep available to teach what we've been and take on the work that we've being expected to do. But at the same time, without holiday pay or with sick leave. So for over 2 years while teaching at Monash, over 100 students, I was also on New Start allowance because it was simply too precarious to be able to rely on the Monash on what I was getting paid on a casual contract at Monash. So you get this situation where I've got a PhD, I've had a lot of experience, I've taught the same courses for many years, but I'm teaching at a tertiary level, but also on New Start payments. So it's an insane situation that this can be a business model where people are teaching at the highest level with the highest qualification, and they're also receiving job seeker allowance because the type of work is so precarious.
Thanks, Dr. Heinrich.
Yeah, thank you, Senator Faruqi, and thank you all very much for the evidence that you've given today. We need to break for lunch now, so I'd like to very much thank the Monash Casuals Network and the University of Melbourne Casuals Network for sharing your stories with us today. Your evidence has been invaluable to our committee. We'd like to invite you to disconnect from the teleconference with our thanks. And I'd like to advise that the committee will now break for lunch and resume at 1:55 p.m.
Thank you, Chair. Thank you, everyone, so much.
Thank you, Senators.
From the University of New England. Thank you very much for appearing before the committee today, Professor Haywood. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones and please ensure your microphone is set to mute when you are not speaking. I would also like to advise witnesses that answers to any questions on notice should be sent to the Secretariat by 5:30 Wednesday, 9 March. I invite you to make a brief opening statement should you wish to do so. For the Hansard record, could you please state your name and the capacity in which you appear?
Good afternoon, Senator and members.
And Professor, could you just unmute yourself if you're muted?
I should be unmuted now.
That may have been from my end, actually. Please go ahead, Professor.
Senator, thank you. Good afternoon. My name is Professor Bridget Haywood, and I'm the Vice Chancellor and Chief Executive for the University of New England.
Thank you. And do you wish to make an opening statement?
Senator, the university made a written submission, so I'm quite happy to take that as the document in front of the hearing and to respond to questions.
Okay, thank you. I'll go to you, Senator Faruqi.
Thank you, Chair. Good afternoon, Professor Haywood. Thank you for appearing before our inquiry. Last year, the Fair Work Ombudsman advised me in response to some questions on notice that I put to them, that it had finalized an investigation into UNE. And as part of this, UNE paid back, I think it was $1.085 million in wages to 1,691 employees. So could I ask if this is the extent of the confirmed underpayments that have happened at UNE?
At the present time, yes, the university submitted an identified issue of underpayment itself to Fair Work, notified them of the processes that we put in place to establish the nature and level of the underpayment, and then reported on the actions that we had pursued to resolve any identified underpayment and how that matter was then closed. So the report that you reference is one that has been before the Commission. We submitted it as an identification of error around underpayment. We've worked with the Fair Work authorities to resolve that. We have one further matter, which again, we put before them when it became visible, and we are in the final stages of resolving that matter. That may lead to an additional payment, but that has not yet been resolved. But it is of a much smaller quantum than the $1 million plus that you've just identified as the first matter.
Mm-hmm. And this is the one, I think, in your submission to this inquiry, it has come after that. Am I right? Or did you actually?
It came following it. So we exposed an issue in the first report. During the work we did to resolve the first matter, another matter became visible to us, largely to do with legacy issues of staff who were originally directly employed by the university, but then have been employed through other means, through university subsidiaries, and the manner in which the adjustment was made to the employment of those individuals by virtue of the contracts that applied at the time, and then those that followed. So on each of the two matters that we have reported, we have self-reported, and we have worked, I think, very positively with the support of Fair Work to use our system of setting up a special committee, having a member of council be present to be part of that process, to do not only the review of the underpayment and how to reconcile that, but also to bring the learning and good practice from that process forward into the organisation.
Okay, and could you tell me what was the value of this further claim or further underpayment?
As indicated, Senator, we haven't yet had a resolution of that. That's what I think we're waiting on the final consideration of, but it is certainly less than the 1 million in the first matter. It's a much smaller cohort of staff with very specialist needs. And I'm very happy to take on notice that I will provide you with a written update on that,
And
on that quantum.
What is the number of the staff who are affected by this?
In the second matter, I believe it's in the order of about 100 staff. But again, I'll give you a specific report on that. Some staff were considered but were found not to be affected by the matter that we raised. And then there were other staff, once we resolved what the underpinning issue was, who became involved in the matter or were captured by the matter.
Okay. And when will this be? When will you know?
I can send you that report on notice immediately. I think we're waiting for Fair Work just to give final consideration to some pieces of information. So we have provided all of the matters that they have requested, and we're waiting on their response.
So have there been any further investigations after this 2020 matter, or was that it?
We have done a comprehensive investigation of all of our casual staff employment methodologies, the gathering of data and the assessment of contracts. And we employed KPMG to do an independent review of the compliance of the university with the relevant enterprise agreements that are linked to this. We've also employed advisors to look at the way our current HR systems allow for us to record casual staff employment, given that some of the issues that we identified were about agreeing the hours and then the hours bleeding out beyond the original contract, and that those additional hours not being properly recorded. And the second matter was to do with casual staff actually holding multiple contracts, and whether the recognition of multiple contracts was being fairly and properly adjusted for. Our current systems do not lend themselves to the automation of that at the level that would give us assurance. So we've had work done to assess how we might change our systems or develop different protocols. And out of that work, through council, we've established a major programme of work around all casual staff employment matters.
Just going to go back very quickly to the 2020 self-reported matter. It's now 2022. I'm just wondering, why has it taken that long to determine the amount and extent of the matter?
The 2021 matter is resolved, and that was the, unless I've confused, that's the million something that you've mentioned.
No,
already.
that was the 2019 matter, as far as I know.
Oh, okay. Resolved in early 2020. Sorry, I apologise.
This one was raised in 2020 with.
And we have been waiting. It has been an ongoing conversation with Fair Work as to what information is required, how we evaluate the quantum of affected individuals. We submitted our report to Fair Work in 2020, and we are in a dialogue with them about resolving it. So it's not
2 years. It's been 2 years now. The staff are still waiting to be paid. So I guess I'm just wondering, what was the delay?
So in terms of aggregate time, you're correct, 2 years. The delay has been in resolving those affected staff, given that many of them are no longer employed by the university, identifying the nature of the contracts that they held at the time that were relevant, as they were legacy employees, and then resolving all of that against which enterprise agreement and which employment agreement was relevant in terms of the resolution of any potential underpayment, and then quantifying that underpayment. All of that has been done manually and has been done with all of our staff operating in remote working mode.
And have casual staff been impacted more in both these cases in these underpayments, or was it completely and wholly casual staff that were impacted?
At this point in time, we believe it was a disproportionate impact on casual staff, and it was a disproportionate impact on casual staff that held, in my language, service-related contracts. And most of the issues have arisen over the locality of decision-making over the letting of the contract and the agreement of the terms of reference and remuneration for that contract. And we have now created a central management unit. So we have stopped devolving responsibility for casual staff employment down to local level. And we are currently establishing a central unit that will be resourced to manage all casual staff engagement, rather than the ongoing risk of it being handled at the site of use, but then arrangements not being properly put in place to recognise the nature of the employment, the quantum of the work being asked for, and how it should be recognised. And then the flow through of that with proper superannuation agreements, for example, not being in place.
Interested in this major program of work that you mentioned around all casual staff employment matters. What does this involve?
So the name of the program is the CORE program, C-O-R-E. The CORE program has drawn information from the external reviews that I've just specified, and in aggregate, we've done a systems review, we've done a compliance with enterprise agreements review, and we've done an assessment of our internal employment processes across the organisation. So the process line from the HR services unit down to the level of, for example, a business unit or an academic faculty unit recruiting casual staff. And they have designed a programme of work that we are about a third of the way through, which is about resolving every potential occurrence where the risk of an underpayment or the less than effective issuing a contract might occur, and resolving what process needs to be in place or what system adjustment needs to occur so that we minimise any of those risks going forward. What has come out of those data is that the key areas of concern are around the letting of multiple contracts to a single casual staff employee who may have a range of expertises and be employed differently across the organisation. There does need to be a much more robust consideration of our responsibilities under superannuation, etc. And the other area is where staff are contracted at very short notice, for example, to support teaching, particularly assessment matters, and particularly the delivery of large classes, where those arrangements are made at the beginning of a trimester before we have final numbers of students. And therefore the agreed quantum of work may not align with the actual responsibilities that a casual staff member may take on as student numbers are confirmed after the census date. So it's a quantum and timing matter, and that goes back to changing the way in which those contracts are let and managed by a central unit rather than at local level.
Professor Haywood, what is the number of casual staff at your university? And I'm talking about headcount here, not FTE.
Thank you. So the headcount is just over, per annum, is just over 1,300. That varies considerably as a function of each trimester in the academic year. We run a 3-trimester academic year. It varies as a function of when we're running assessments. So when the periodic running of formative and summative assessments. And then we have another variation, which is the running of major projects. So at the moment, we have a major project to redevelop the learning management system, the Moodle platform and the learning management system. It is our habit, because we're a regional university, to bring on a range of casual staff to either backfill or support key technical aspects of major project delivery. So we have various waves, if I could describe them as that, where the casual staff numbers will drop and then they will rise again very quickly, dependent on student load, academic time of year, and project portfolio delivery.
Professor Haywood, we've heard again and again from academics in this inquiry and in another inquiry that I sat on, which was on job security, which was also a Senate inquiry, of the inextricable and the very close link between casualization of university workforces and wage theft. And having been an academic myself for many years, I completely agree with that analysis. So a recommendation of our recent Senate Job Security Committee was that the government require universities to set publicly available targets for increasing permanent employment and reducing casualization. and report their progress against these targets at an annual basis. I'm just thinking, has UNE done anything to wind back casualization? And would you be open to doing this voluntarily, setting some targets that increase permanent employment and reduce casualization?
So first of all, fully aware and support the framework of those recommendations. And for the this hearing's benefit, I was involved in the United Kingdom where instruments of policy were developed to reduce fixed term and casual staff employment within academia, and to frame a better way of supporting what I believe is professional career development and professional career opportunities along a career pipeline. The university included consideration of that in the major organisational programme it ran in 2020-2021 called Time for Change. We have adopted an integrated services model, which means that what we do is we build professional portfolios around cohorts of staff who are mobile around the organisation, but are consistently employed on permanent contracts as a function of the expertise that they already bring and of the skills and career development that we can offer to them. And that's been part of our integrated services model. And we have targets already in place for that.
So you have targets for converting?
We already have targets in place for our expectation of the criteria that would be used to support conversion. And I'm happy to say that we were developing those in advance of the casual staff conversion legislation being formalised.
Sorry, just let me be clear, Professor Hayward. So you have targets for increasing permanent secure work and reducing casualisation?
We have a target for our workforce design, which includes those measures, correct?
Okay, so, and what are they, like in 5 years' time? How much do you want to reduce casualisation by, for instance?
So we would expect for a regional university offering a comprehensive portfolio for remote, regional, rural students, that we would have a ratio of permanent staff, and that's permanent staff across the organisation, to drawing on the expertise of casual staff, that our casual staff should not be more than 30% of our total workforce at any point in time.
30% still?
Well, that would be 30%, but it would be across not headcount, but a range of FTEs. We have people employed from 0.1 up to 1 FTE in the manner that I've described. We deliver a comprehensive range of subjects where a full-time employment is neither appropriate nor in fact sought by the individuals who are engaging with us. So we have to balance both what's desirable for a certain cohort of staff. We are the only university teaching Indonesian as a modern language, for example. We don't have a justification for full-time staff employed in that, but we have staff who are competent in the culture and languages of Indonesia who work with us as well as other organisations. So what we're trying to do is move them from having casual or fixed term contracts to being permanently employed on fractional contracts. And we're looking at that as part of workforce design.
Yeah. What is the ratio at the moment? You said there were more than 1,000 casual staff.
We have just over 1,000 permanent staff, and we have 1,300 on-register casual staff. So in any one whole year, the ratio is 1-to-1.
Okay, so it's, yeah.
Okay. Senator Faruqi, I think it might be beneficial to put some of those data questions on notice, if possible, just because of the time. So apologies, I do need to move on to Senator Scarr now. Senator Scarr.
Thank you very much, Chair. Professor Hayward, we've heard evidence today from a number of individuals who have been employed as casuals at various universities, and to be open with you, they all came across to me as very sincere professionals seeking to do their best. And it was a recurring theme that they felt pressured covertly, overtly, by the structure of their engagement to either shortchange themselves in terms of how much money they were earning, or shortchange their students in terms of the time which they could provide, be it through tutorials, marking, class preparation, what have you. As a very experienced senior executive in higher education. Do you have any general comments about this phenomenon and the pressures facing casuals in a university context?
Thank you, Senator, and I'll bring what experience I can to bear on this. I come from an environment where casual staff are a lower component or a less obvious component of the workforce compared to the way that we do use them here in Australia. So I have experience of working in the United Kingdom and New Zealand and Europe. So to the extent that we use casual staff, there's an element of it that's quite unique now to Australia. That would be my first comment. Secondly, I think your comments and the comments you've reflected as representative of witnesses who've appeared before you, I think there is an issue about needing to be very, very clear what the purpose of the casual staff role is within the academic context. That you're very clear whether these are individuals who are wishing to pursue scholarly and academic employment as part of a broader portfolio. I've described, for example, teaching Indonesian languages, that we attract for a number of important but minor languages, a range of people with a range of expertise who come in to support the broader academic programme. You then tend to have casual staff who might also be operating as research fellows, or they may be doctoral candidates who are looking to grow their professional expertise and recognition in order to have a career development pipeline into an academic role or something similar. And my experience has been that we all have to be very careful, first of all, in defining the task. And I think that's where the academic workload agreements that sit under our enterprise agreements could have more purchase. That we need to have a better description of what work is expected to support a student. And all universities, I can speak for mine, but I suspect I share the views of many other universities, all universities are minded to be much more explicit about what constitutes effective and meaningful student support for the quantum of work that the students are asked to do, for the quantum of support, formative and summative assessment and feedback that is required to enable a successful student journey. And then for me, probably the sore point, it's the development work that's put into supporting casual staff so that they receive appropriate professional development to be part of the modern academy and to be enabled in modern pedagogies. And this university, that's given that 70% of our students are external, which means they study online through distance education methodologies. We offer a particular program of intensives, which we depend on casual staff to support us in, particularly for health and safety matters and for quantum of feedback per student, so staff-student ratios, etc. We have quite well developed methodologies for that because of the nature of the delivery of our programs. But we, along with every other university, know that we need to play a better part in defining what is an academic task, what represents an appropriate delivery of that academic task in support of the student, and how we develop our staff so that they are not faced with issues about effective support, but they are confident that if they wish a career track, that they are being appropriately developed in that mode.
So are you confident that at your university, there are no practices such as, and I'll give you two examples that we heard from witnesses earlier today. One was people being invited, asked to perform what I would see as work in return for gift cards instead of proper remuneration. That's one example we heard of today. Another example was casuals feeling overt, to be frank, pressure to categorise work as other academic work as opposed to tutorials, so that they would be paid at a lower rate than what the substance of the function they are undertaking would warrant. Are you confident that those practices don't occur within the University of New England? And if you are confident, I'm very keen to know what processes, internal audit processes, you spoke about having external service providers, but what internal audit processes the University of New England has to make sure that those sorts of practices don't occur?
So, Senator, given that you've asked that question in a very particular way, I can't assert with 100% confidence. It is not part of our process by policy, rule or guideline to offer vouchers in return for a remuneration of work. Let me categorically state that if a witness came forward from this university where that had occurred, it would be a disciplinary matter for the unit that supported that activity. It is simply no part of our culture, and I personally and most assuredly would join you in criticising, shall I put it that way, and dealing with that matter. It's no part of our guidelines that would be a method of remuneration.
Okay, you made that very clear. So the second category of casual staff feeling pressured to classify, say, something which, based on my old university experience, I would call a tutorial as other academic activity which is paid at a lower rate. That sort of practice or phenomenon?
So, Senator, I have heard it described. Can I absolutely assure you that that doesn't inhabit our institution? No, I cannot. But the actions that we have been taking to support the avoidance of that situation is through our enterprise agreement and moving from an EFSL-based model to an hours-based model with a programme of task envelopes. So the best way in which academic work models work is to have a clearly defined programme of task envelopes. You describe them as academic tasks. There are academic tasks that must be done by academics who meet the AQF+1 requirements. And there are academic support tasks that may be undertaken by individuals other than academics, but must be supervised by academics. So this university has fought very hard to put itself in a position where it has an academic hours-based workload model that is supported by defined academic tasks. And having then defined them, the rate of remuneration is then articulated very clearly by both the enterprise agreement and by our own work practices. I would like to reflect carefully that we are in a dispute with the NTEU over the implementation of our hours-based model. So whilst we identify that that is our modality, that is the commitment we've made in our enterprise agreement, I think possibly for me to say more might put me in a position that disrupts that dispute process.
And I don't want to put you in that position.
No, I know you don't. So I'm just trying to answer you as fully as I can, but not step over. I appreciate
that. And my last question, when I hear about some of these practices, for example, the gift cards or academics, casuals in particular, feeling under pressure that they've got to categorise work in a way that isn't going to give them the pay which they're entitled to. From my perspective, it comes down to, or back to the culture of the organisation and the leadership within the university itself. Do you think a lot of these things, these phenomenons, do come back to leadership and the culture of the university, that ideally through the leadership of people like yourselves in a university, the expectation with respect to what is acceptable or not acceptable on the basis of core values such as respect and integrity, some of these things just shouldn't occur, and people shouldn't even think of putting people in a position where they've got to make a choice between shortchanging themselves or shortchanging their students. Do you think that's a fair comment?
Senator, the responsibility for that culture starts with our council, and I can reassure you that our council take this matter very strongly. To your point, I am the Vice Chancellor and Chief Executive Officer, so myself and the executive that support me are the second visible instrument by which the tone, the purpose, and the commitment of the university to fair and honest employment is made visible. To your third point, that we operate under a set of values. The university has just published in the last year Future Fit, which is its new decadal plan. It operates under 4 clear values: openness, to be exemplary, to be inquiring, and to make a difference. And all of that connects to the fact that we are a leading regional university and have a responsibility to set standards at every level, not only for how the university conducts its business, to be exemplary as the largest corporate employer for the New England Northwest region. So we take those responsibilities very seriously. I, like you, could only express in the strongest possible terms my dissatisfaction if I discovered that any remuneration around service to support teaching was being covered off by the offering of gift cards rather than an appropriate contract for employment. and an appropriate recognition of why we contract, which is about meeting our quality assurance standards, ensuring that our students get the best possible education that our standards will support and allow, and that we are a demonstrable evidence of meaningful employment, not only for our own staff and our university, but that we also echo that into the students that we support. Over 70-something% of my students are mature age students of 30 and over, being trained in the workplace. At the moment, 69.8% of my students are women seeking entry into the workplace on the basis of securing qualifications that render them fit to be part of the workforce. This university was founded on the agenda to serve need through education and engagement. If we were to participate in a form of employment engagement that destroyed all of that ambition, then we are not the institution we stand up to be, sir.
Okay. Thank you very much, Professor Haywood.
Yeah, thank you, Professor. We would like to thank you very much for your evidence today and invite you to disconnect from the conference with our thanks.
Thank you,
Senator,
Professor.
may I thank you all? Do I understand that you will provide me with questions on notice for data, or do you want me to take the questions that I believe I heard today and provide those data, just to be clear?
Senator Faruqi?
Yeah, if you could provide those, that will be fantastic. And if we have anything over and above that, Professor, we'll send them to you through the committee. Thank you so much.
Senator Faruqi, I will send according to your questions and then we can go forward from there. Thank you very much, everybody, for your time.
Thank you, Professor. I now welcome representatives from RMIT University. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones and please ensure your microphone is set to mute when you are not speaking. I would also like to advise that answers to any questions on notice should be sent to Secretariat by 5:30 Wednesday, 9 March. I invite you to make a brief opening statement if you would like to do so, and for the Hansard record, could you please state your name and the capacity in which you appear?
Yes, hello. I'm terribly sorry. It's Fiona Higgins from RMIT. I'm speaking as a former interim Vice-Chancellor of RMIT, and I'm so terribly sorry. I had some tech difficulties, so I haven't been able to hear you, so I'm joining from my phone.
Okay, that's fine, Ms Higgins. We can hear you loud and clear. And we also have you, Professor Sherman Young.
Hello, I'm Professor Sherman Young, Deputy Vice-Chancellor Education at RMIT.
Thank you. And would either of you like to make a statement, or shall we proceed to questions?
No, that's fine. Maybe if I could begin with an opening statement. Thank you very much. So I'd like to provide some context as to why I'm representing RMIT today. As I said before, up until mid-January, I was the interim Vice-Chancellor of RMIT. And before making this opening statement, I'd really be pleased to respond to your questions. So RMIT takes its obligations under its enterprise agreements very seriously and committed to ensuring that employees have received their full entitlements. If concerns are raised, we investigate and take action. And I'd like to give you an example of how we live up to this commitment. You may be aware from media reports late last year that the NTEU raised a dispute with us about whether a higher rate of pay, known as the academic judgment rate of pay, would have been paid to casual academic employees who were instead paid the standard rate for certain marking work. The rate that is applicable depends on the work that's being done. As part of our periodic reviews of our systems and processes, we had commenced a review of our payment compliance before the dispute was raised. The NTEU provided us with some information as well. We concluded that any issue was due to inconsistency of application of the rates based on subjective human judgment. No other underlying causes were identified. RMIT had paid casual staff the higher academic judgment rate for the majority of assessment work over the period of the dispute, which went back to July 2014. However, we would have needed to verify that every single payment of the standard rate for marking work had been correct. To verify, this would be an enormous, prolonged exercise requiring review of tens of thousands of assessments across thousands of courses and reconciliation of nearly 100,000 timesheet entries and associated pay records. We value our casual employees and we're very aware of the distress, uncertainty and frustration that such a protracted process would cause. To ensure a timely resolution, RMIT proposed to the NTU that each standard rate marking payment over the period be increased to the academic judgment rate, irrespective of the type of assessment actually completed. The NTU accepted this proposal. This means that every affected current and former casual staff member would receive an additional payment without having to establish any entitlement or to wait for an extended period for their individual claim to be assessed. I want to be clear that RMIT did not determine whether the employees being provided the additional payment had actually been underpaid. The settlement was reached without any admission of wrongdoing. We have undertaken a number of actions to ensure this issue does not reoccur, including investing significantly in new systems which enable the employees themselves to categorise and self-enter time. We've also agreed a position with the NTU on when academic judgment rates do apply, and we've run sessions with all of our schools to ensure that this position on when to apply academic judgment rates is well understood and applied consistently. Most importantly,
Ms. Higgins, yes. Higgins, sorry, as you know, we're on a really tight time frame, and I'm just wondering if there's one more sentence you wanted to share, and then I'll pass the call to Senator Faruqi, please.
Sure, absolutely. I guess probably the last point I really just wanted to make is that we really are committed to creating a culture where there is transparency and we build confidence that when matters are raised, that they will be investigated and addressed. And so that was the main conclusion I wanted to say.
Thanks, Ms. Higgins. Senator Faruqi.
Thank you, Chair, and good afternoon, Professor Young and Ms. Higgins. In November last year, it was reported in The Age that RMIT has struck a deal with the National Tertiary Education Union to back pay all current casual staff a total of $7.5 million plus interest and superannuation by the end of the year, and to make all reasonable attempts to contact and pay affected former casual employees. I'm just wondering if this process is now complete and what was the repaid final total?
Thank you, Senator. This process is actually a working process. So what we did by the 17th of December, I think it was 1,411 casuals exactly, we actually updated the payment rate to the higher academic judgment rate. So that was processed through that pay period. And now we're in the process of contacting, we will actually launch later this week, to former employees. So we'll be going out through a range of where we have email addresses or contact details to contact those former employees directly, and we'll be making every effort to make that additional payment. In terms of the total amount, so it is estimated to be around the $7.5 million. On top of that, we would be adding the interest charges and superannuation for the term of the period. So so I think that brings us to around about $10 million.
And is that for former and current employees?
That's correct.
And how many former employees? You said current was 1,411. How many former employees have you contacted?
So we're about to launch that. It has taken a month or so because we're building a safe portal where those inquiries can be placed with a 100-point check, etc. So we expect that will be about 2,500 that span that period back to 2014.
So 2,500, did you say?
That's correct. That's our estimation.
Yeah, and what percentage of these employees are casual or were casual employees? Was it all of them? Were all of them casual?
I would just have to take that on notice if I could. My understanding is that they would be casual. Yeah, well, they would be because they wouldn't be, otherwise they'd be on a full-time rate. But I will double check that. I'll take that on notice if that's okay.
So all 3,500, I think you presume were casual. Yeah. What proportion of those casual staff were women? And you can take that on notice or even provide me with an estimate now and take that on notice.
Certainly, yes, I would need to take that one on notice.
Okay. Are there any current or new investigations ongoing at RMIT into further instances of wage theft?
So I probably will start by saying that, as I was saying in my opening remarks, we absolutely do not agree with the notion of wage theft, and that is not an activity that RMIT has undertaken. And so I say that as a beginning, we absolutely stand with the Senate in terms of that is not a practice that we would undertake, and we absolutely believe in paying our employees appropriately as to their entitlements. And we make a lot of efforts to ensure that that does actually occur, as you would expect. That's our obligation. So in terms of your question regarding do we have any other disputes underway, there is one outstanding dispute that I understand that is a matter that remains before the Fair Work Commission, and it's specifically in relation to a dispute in our School of Management relating to the way marking time was allocated to casual employees in the School of Management. So we've been working proactively with the NTEU to reach an understanding on an agreed new framework, and even in advance of that have been working, of course, to understand the issue at hand and working directly with our employees. But that matter is still outstanding in relation to the Fair Work. That is the only one that I am aware of.
And do you work with your casual employees as well? Do you engage with casual employees directly?
Myself?
The university in terms of these matters.
Oh, yes. So, of course. Sorry, I didn't understand the question. Yes, so of course the university engages with casuals directly. We encourage them to bring any areas of concern. We have sophisticated processes and policies in place to deal with complaints and to be investigated. So, and we would encourage that very much. We want to hear from our staff if they have any areas of concern. We'd encourage them, and as I was sort of saying in my opening remarks, we create the culture where we actually would encourage them to come forward.
In a recent submission to the Job Security Senate Committee, which is another inquiry that I'm on, your colleagues at the University of Melbourne stated this, and I'm reading that statement. The university has made public its commitment to addressing the issues of insecure employment and casualisation. And the Vice-Chancellor and Provost have both personally conveyed a conviction that this provides neither a sustainable nor a desirable model for the future of the university. Does RMIT have the same conviction that the casualisation model is neither sustainable nor desirable?
So thank you, Senator. So RMIT has the commitment that we are absolutely committed to paying our employees within the terms of our enterprise agreement, of which we develop in good faith and fair bargaining. So I think that I would start with that, and that we have our commitment to pay our employees fairly for the work that is done.
But that is not my question, though. My question is that University of Melbourne has said that the casualisation model is unsustainable and not a desirable model. What does RMIT think about that? Because we know that casualisation of staff and wage theft, underpayment is inextricably linked. We've heard that again and again. So do you have any targets or any plans to reduce casualization and to increase secure work?
So, in any year, we regularly look to convert our casual staff as appropriate as set out in the enterprise agreement. The matter that I'm here to respond to today is relating to specific underpayment of the employee remuneration, and I think that's what I've stressed. But I am happy. Maybe I could call on my colleague,
that would be good.
Sherman
Yeah,
Young,
maybe
who
Professor
may want
Young
to add to
can
this.
answer that question. So my question to you is, we know that wage theft is inextricably linked with casualization. Melbourne University has said that they don't think a model of casualization, which most universities operate under, is sustainable. Do you have a similar view, and do you have targets to reduce casualization and increase secure work?
So I think in the first instance, Senator, and thank you for the question, we have to understand the different types of reasons why casual staff are employed. So certainly we have PhD students, for example, with research commitments, so they can only be casual staff. We have industry colleagues who come in to the university from their full-time work in order to be able to engage with education and to support the next generation, if you like, of learners. And they too would be casual staff. We also have visa holders, international students who have our work hour restrictions in terms of how much they can work. And we also have some casual staff who are very happy to gain opportunities across several universities. Having said that, I do totally acknowledge that there are casuals who are looking for an academic career, and we are constantly looking to improve those opportunities for developing academic careers. We're actively working with the NTEU to look at what the job families look like and how we might progress that. We are collaborating with appropriate stakeholders towards that goal. And certainly are working towards an ambition to convert more casuals into an appropriate academic career if and when possible. We don't currently have...
Sorry, keep going.
I don't have a target to hand, but I can absolutely take that on notice and we can work with...
Has the university developed targets? Surely, as your position as Deputy Vice-Chancellor Education, you would know if the university has targets, if the university has plans to address this issue, which is quite systemic. And we have heard from casuals upon casuals for the last 2.5 years who are underpaid, overworked, would love to have a secure job, but just because universities run with this business model. So I guess my question is, do you have targets? Surely you would know that if a university has a plan to convert casuals to secure employment and increase secure employment and reduce casual workforces.
So we do have plans to work towards an appropriate outcome for more of our casual staff. I don't have the targets to hand, but I'm very happy to bring that back.
Yeah, that'll be great.
Senator Scarr.
One more question.
Senator Scarr, Senator Faruqi, if we have time, we'll come back, but we're now over time. My apologies. Senator Scarr.
Thank you very much, Chair. If I could direct my questions to Ms Higgins. Ms Higgins, you push back very strongly when the term wage theft is used. Why?
In relation to the historic example that I'm speaking about today, so this is why is RMIT paying its casual staff this amount? It's specifically in relation to this specific set of circumstances is that we deemed in this case, so when we wanted to go back and understand historically, had there been underpayment between the use of academic judgment rate and the standard rate, the effort to go back and try to analyse all of those records was so great that we made the decision to make this settlement regardless of whether there had been an underpayment to all of the staff that had undertaken this work over the period of time. So
that's a commercial judgment, isn't it? And when I look at it, and I've come from the mining industry. I've been part of big payroll operations. You have objectively looked at the situation and decided that you don't want to go through the process of trying to reconcile all of these payments. Therefore, you've made a decision to make these payments because on the one hand, you can pay the compensation. On the other hand, you can incur all the costs incurred of going back in time and analysing the data. And I can only try to imagine how big a task that is. But isn't the essence of it that the people weren't paid what they were entitled to, or you aren't reasonably comfortable that they were paid what they were entitled to? Doesn't it just come back to that?
Yes. To your point, it was a complex exercise, and I think that, and so what I'm saying is that we have the ongoing commitment to ensure that people are paid what they're entitled to. What we've done is, and so in this matter, so rather than say this is about wage theft, I actually see that we had an opportunity for human judgment or perhaps an inconsistency of approach to be applied because of potential complexity in our systems. What we've done since then is we've actually rolled out and made a significant investment in our systems to ensure that we are now putting the onus in the hands of the academic to that the systems are such that they are the ones that can enter their own timesheets, so they get to select the judgment rate. We've also rolled out specific training as well to ensure that there's no inconsistency. So I guess where you hear my objection, it's the characterisation of wage theft and the connotations that implies. That is not what we found through our investigations. We found an opportunity for misinterpretation, but the recommendations for how it should be applied were there. What potentially we were wrestling with was the local application in some circumstances. And so we took the decision to pay at the higher rate.
Okay, but when I'm looking at it, I'm thinking either A, it was a gross administrative cock-up across the board, right, in terms of your payroll system, in terms of HR management, or B, there was a systemic issue here in terms of conscious decisions being made by whoever has the authority within the organisation to try and err on the side of paying at the lesser rate than at the greater amount. Either way, there's been a serious issue, and I call it what you want, but it was a grave failure of process. Is that a fair comment?
So I wouldn't. They're your words, Senator, not mine.
No, they are my words. I'm seeking your input. You seem to be downplaying it. When I'm looking at it, and I'm coming at it with a fresh pair of eyes, and I'm seeing you paying millions and millions of dollars to casuals, your most vulnerable employees, cohort of employees. You're having to go back years in order to do that. And I'm looking at that, and I see that as a material failure of governance. Do you accept that proposition?
So, Senator, no, I don't accept that proposition because, as I was saying, and maybe I can ask Professor Young to speak to actually how the application of why this would not have been easily picked up in terms of how the application of the judgment rate. So I might call on Professor Young to speak, which might bring a little bit more to light.
Sure, and Professor Young, before you do speak, I've been a senior executive in a mining company with 4,000 people. If I reported to my board of directors that we'd underpaid our miners $8 million over a period of 5 years, my board would say that has been a material failure of corporate governance. Do you understand why I'd make that observation?
So yes, thank you, Senator, for the observation and for the question. I guess I'd like to illustrate with an example that the type of judgment that I think is in question here or is in discussion here. So when it comes to assessing academic work, and I know that some of the senators in this panel have experience in this space, so I respect their experience as well. But there are a number of different types of assessment that might be undertaken by a student, ranging from an essay, an assignment which requires short answer questions, project reports, numerical tasks, simple yes/no answers, multiple choices, etc., etc. And the application of the different rates of pay was, according to the enterprise agreement, based on a judgment about which of those tasks required academic judgment and which didn't. Now, some are pretty clear cut. So, for example, one could argue, and I would, that a multiple choice exam where marking could be done with a little bit of a template across the multiple choice requires no academic judgment. Others get a little bit grayer. So short answer questions, for example. There are some short answer questions where the answer is needs to be expansive and well justified, even though it's short. There are other short answer questions where the answer is far more straightforward and could be argued require way less academic judgment in terms of the marking. So what we're talking about is an application of judgment by the course coordinator around whether the assessment task actually required academic judgment or didn't require academic judgment. Now, I make no, sorry about the pun, judgment on the ability of those course coordinators to make that judgment. But what we determined over that period of time was that there may have been instances where the judgment fell on the wrong side of the line, and rather than have to go through that entirety of investigation of all of the assessments, of the timesheets, etc., it made sense for us to actually apply the higher rate despite not having done that work, in the knowledge that in some instances, perhaps we were erred on the side of generosity, perhaps.
Professor Young, if I could interrupt for 1 second, Senator Scarr, I don't think it's reasonable to blame course coordinators.
I'm not blaming.
Yes, you did. You said it was their judgment. And I think universities and managements who are paid huge pay packets should actually take responsibility and be accountable for these underpayments and systemic wage thefts that go on.
So if I could just add to that follow-up question, Senator, we have taken that responsibility, and what we've now got in place to mitigate against those challenges is a much more clearly articulated sense of where academic judgment should be applied and not. We've agreed that with the NTEU. There is now a far more clearly delineated, I suppose, barrier between judgment and non-academic judgment. So yes, we have taken that responsibility. We have learnt that lesson, and we acknowledge that we have now progressed.
So doesn't that mean, Professor Young, and this is my final question, doesn't that mean that before you introduce these new systems, these new checks and balances, this new rigour in your pay process, before then, there was a failure of governance. There was a failure of the systems. Otherwise, you wouldn't have to pay back the millions and millions of dollars of compensation. Do you see why that's obvious to me looking on the outside? I know you're resisting saying that. I just query to what good or what benefit that is.
Yeah, no, look, I don't disagree that things could have been improved, and we have improved them. I think casting them as a failure are words that I will not choose to use.
Okay, fair enough. Thank you, Chair.
Okay, thank you very much, Senators, and thank you very much, Professor and Ms Higgins. Thanks for your evidence. We'd now like to invite you to disconnect from the teleconference with our thanks. We'll go to our next witnesses.
Thank you.
Thank you. I now welcome representatives from La Trobe University. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I would also like to advise that answers to any questions on notice should be sent to Secretariat by 5:30 Wednesday, 9 March. If you have a brief opening statement, I invite you to deliver that. And for the Hansard record, could you please state your name and the capacity in which you appear?
Thank you, Senator. My name is Professor John Dewar. I'm the Vice-Chancellor of La Trobe University. and I'm joined by my colleague, Ms. Regan Sterry, who's our Executive Director of Human Resources. I do have a short statement, which I will get through as quickly as I can. Thank you for the opportunity to appear before you today. I just want to say at the outset that our casual staff are very highly valued members of the La Trobe community. And like every university, we believe it's absolutely vital that they are paid fairly and equitably for the work they do. Now, you'll be aware that I wrote to your secretary, Mr. Fitt, on the 18th of February of last year in response to the submission you received from the La Trobe Casuals Network. And I just wanted to briefly update you on developments in the last 12 months. So what I'm going to do is give you a quick overview of the findings from the independent review and audit of La Trobe's payment practices for casual staff that we conducted last year, and a quick summary of the outline of the actions we're proposing to take in response, or are already taking in response to that review. Now, we initiated a self-review in late 2020, not because any concerns had been raised with us by our own staff, but because we knew that there were concerns in other sectors and starting to emerge in higher education about underpayment of casual staff. So we initiated this review ourselves, and the review was supported by the NTEU, to whom we're grateful for their continuing assistance throughout the review process and now as we move into implementation. The review was completed in 2021, and what it did was to identify some issues with our systems and processes, which we now know led to the underpayment of some, by no means all, in fact a minority, but a significant minority of our casual staff. In response to those findings, we conducted a deep dive analysis of our payments to our casual staff over the last 6 years. That is from the 1st of July 2015 to the 30th of June 2021. Now, this was very complex and assessed more than 1.2 million rows of timesheet data relating to more than 11,000 employees over that 6-year period. We completed that analysis of payments last year, and we identified a number of casual staff in some parts of the university who had been inadvertently underpaid owing to poor systems and processes at the university. And I'll come back to that in a moment. Now, we were very disappointed by those findings, and we apologise sincerely to all the affected staff. These underpayments were not intentional, and we deeply regret that they occurred. The total underpayment over the 6-year period to the 30th of June 2021 was $3.5 million. The average underpayment per staff member was about $891, inclusive of superannuation and interest. We've taken immediate action just before Christmas to pay all of the currently employed casual staff repay them any underpayments up until the end of June 2021. And these payments were made to those staff on the 17th of December. We've also been contacting former casual staff who've worked for us over that 6-year period and who we think have also been paid incorrectly. This will take some time, but we're working with third parties such as UniSuper to try and track down those staff members so that we can pay them. We are completing the analysis to cover the last 6 months of last year, and a further payment will be made to affected staff in April of this year. That payment will also take...
Sorry, Professor. I understand that you've circulated this statement to the Secretariat and the Senators all have copies of it. So I was wondering if you want to just give us your last thought there, and then I'll hand the call to one of the Senators.
Okay, thank you. I've almost finished anyway, but during that review that we conducted last year, we uncovered a further source of underpayment or possible underpayment relating to marking rates, and we are working on that. Firstly, to estimate the extent of those underpayments and to remediate them, and then to fix our systems into the future. We've taken a number of steps. We are implementing all of the recommendations from the audit, and I'd be happy to discuss those further. Our aim is to remediate all underpayments by April of this year, and then to conduct annual audits into the future to ensure that we continue to pay our staff accurately and fairly for the work they do. Sorry to take up your time.
No, thank you very much, Professor. Sorry to cut you off, and I'll go to Senator Faruqi.
Thank you, Chair. Good afternoon, everyone. We've heard today and also before today from many casual employees of your university and also other universities who have told us how much they fear repercussion and punishment if they speak out about underpayments. Some had to appear anonymously today. Others have told us that they have lost their, kind of casual employment when they have spoken out. And the University of La Trobe Casuals Network actually did a survey which tells us that 49% of the respondents, and these are all casual workers, said that they would fear repercussions, even for just asking about whether they were paid for all hours of work. You had told us earlier that you valued your casual staff. So tell me how you reconcile this. Your staff, definitely, casual staff, don't feel valued. And what are you doing about this fear that is amongst your casual staff?
So I'll ask Regan to address the second question in a moment. But it is certainly not our intention to create a climate of fear. And as you'll hear in a minute, we want to do everything we can to enable our casuals to raise issues or concerns they might have about underpayment in a way that is safe, or in which they feel safe, and that takes it out of the relationship of the employing academic member of staff and the casual member of staff. But I'll ask Regan just to fill in the details.
Just very quickly, if you could tell me, what are you doing and why has this fear become a culture? What have you been doing or saying to your staff for them to fear speaking out?
I dispute whether it is a culture, but I'm not sure that even matters.
49% of the staff are saying that. So I think that's the problem.
Even if it's one,
listen to your staff.
Absolutely. I think though, even if it's one staff member who says that, then that's something that we absolutely have to address. And we are. So there's actually a couple of ways to go about this, and we are looking at it both from a upskilling the managers so that they're aware, that supervisors are aware that they need to be having these conversations with their casual staff members, and that is absolutely appropriate for them to have those conversations, that they shouldn't just be sending the casual on their way if they don't want to have those conversations with them about how they're working and their workload and their payment structure. The other component of that is if that conversation doesn't happen or isn't appropriate, or the casual doesn't want to have that, we need to have another mechanism, and that's going to be through HR. So we're going to set up a dedicated channel for casual staff members to come through if they have had those conversations or don't want to have those conversations, to put their concerns through to HR, and we will deal with them with the manager and the staff member. And that way we'll also know that those conversations have been going on. So we'll know that therefore if that casual staff member then comes and says, well, now I haven't got any work next semester, we'll absolutely have a record of that and be able to go to those managers and seek more information about that. But we need to have a number of ways to do that. And like I said, it doesn't matter if it's one or the 49% of those people that responded, the 140 that responded to that casual survey. We need to do that, and we need to do it better.
Senator, if I could just add that our goal is that no casual should feel that they are being underpaid. It is to fix our systems and our processes to ensure that everyone gets properly paid, so that there's no need for a dispute. But if there is, as Regan has said, we plan to strengthen essentially the appeal process so that casuals can feel that they can query their remuneration without incurring the wrath of a supervisor.
Professor, they don't feel they are being underpaid. They actually are being underpaid. In the latest admission from La Trobe on the underpayment of $2.5 million, which was reported just yesterday, and that comes after the $3.5 million paid last year. Have these both come from the same independent audit?
Sorry, Senator, can I just say that the majority of our casuals are properly paid. The audit found that out of 11,000 casual employees over the last 6 years, about just under 4,000 had been underpaid to some extent.
Yeah, that's about 35, 40%. That's not a small amount.
No, I absolutely accept that. But
you said it was only a small amount are underpaid.
no, I said it was a significant minority, and I accept that. But you were suggesting that all of our casuals are being underpaid, which is not the case.
I wasn't suggesting that. I understand that part of the 3.5 million underpayment was due to management breaching the enterprise agreement by failing to observe the 3-hour minimum engagement period. And I just want to know, as part of this independent audit or your discussions with the NTEU, have any other breaches of the enterprise agreement been identified?
Well, the audit is quite clear, and the audit's up on our intranet as well for staff members to see that there were, a number of areas that were incorrectly applied. So it's whatever you consider to be a breach of that agreement. But clearly, people, and it's shown in that document, we had people who were being paid for a non-PhD rate when they had a PhD. We had people who were paid for second lectures when they should have been paid for first lectures or tutorials. And we had some issues with our nurse education payments as well. So so it just depends on how you characterise it. We've been very open with staff about where those.
As a breach, but have you acted on all those potential underpayments identified by the independent audit?
Yes.
Yeah.
Yep. So you said, yep. Sorry.
So we've remediated all the underpayments attributable to all but one source, and the one that we haven't yet completed is the marking, which goes to the fitness for purpose of the marking guidelines that our supervisors use to assess the degree of academic judgment that has to be applied to a particular marking exercise.
And
so
when are you expecting to fix that?
By April of this year is our intention. That's our expectation. Yeah.
Yeah. And you said 4,000 casual staff had been underpaid. How many, could you just maybe take this on notice, how many of the staff were women out of those 4,000?
We can take that on notice.
Yep, that'll be great. In a recent submission to the Job Security Senate Committee, which is another committee of the Senate, the University of Melbourne said that the university has made public its commitment to addressing the issues of insecure employment and casualization, and that the Vice Chancellor and Provost have both personally conveyed a conviction that this provides neither a sustainable nor a desirable model for the future of the university. I'm just wondering, is that something that you are willing to look at? That basically casualization, and it is pretty rampant in universities across Australia, is not a sustainable nor a desirable model. It does lead to wage theft and insecure work for people who have told us, inquiry after inquiry, how their lives are affected. So my question to you is, do you have any targets, any plans to reduce casual employment at your university and increase secure work?
Yes, in short. I'll begin and then hand to Regan again. So firstly, we have been reducing the proportion of casual staff in our workforce over the last 4 or 5 years. On an FTE basis, it's dropped from about 16% to about 11% since about 2016.
What about a headcount basis?
Yes, it's dropped on a headcount basis as well. I can give you those numbers. So it's dropped from about 7,000, about 4,500 in 2016 to last year 3,300.
And how many of those?
Senator Faruqi, my apologies. Can I just indicate to you that we are a bit behind time, and Senator Scarr has some questions, and I was wondering if you would mind putting some of those questions on notice.
I can put them on notice. Basically, I wanted to know how many of the 4,500 have actually been converted and not got rid of.
Okay, we can.
And I can ask some further questions on notice. Thanks.
Yeah.
Thanks so much, Senator Faruqi. Senator Scarr.
Professor, is underpaying 4,000 out of 11,000 casuals a systemic issue? And if it isn't a systemic issue, what do you call it?
Well, clearly there is a systemic aspect to this. It didn't apply to all casuals, and it seems to be concentrated in some parts of the university. So there are clearly some parts of the university where you could say that the issue has been systemic, but I wouldn't characterise our entire casual payment system as at fault. Clearly, there are some contributing factors. The complexity of our industrial arrangements is one. The outdated nature of our systems, which allows people to enter incorrect information leading to underpayments, is another. And devolved decision making. We necessarily have to rely on academic staff in spread across the university to make these decisions, and that inevitably leads to some inconsistency.
Okay.
So what we're doing in response to the audit is to try and address all of those factors.
Okay, we've only got limited time. During the testimony, both you and your colleague on a number of occasions have referred to staff putting in the wrong information, providing the wrong information. When I'm looking at some of these case studies of the casuals, let me quote from one. This is what this casual says: constantly being asked to claim less than what I was paid. In a strange way, I was relieved to be unemployed this semester because it greatly helped my mental health despite now being broke, end quote. So from my perspective, that connotes not systems and processes, but a cultural issue, at least wherever that person was working, that there was an expectation that they would put in the wrong data into the system because there was over pressure applied on them to do that by whoever it was under your devolved decision-making process. And from my perspective, that goes to culture. That goes to culture. That's not systems and process, that's culture. Can you see why I would think that?
Yeah, I absolutely can. And where that's happened, it's completely unacceptable. And if that applies in our own institution, then we have to fix it, absolutely.
Well, there are 4,000 casuals who weren't paid what they should have been paid. To what extent is your investigation, your review, digging down to see whether or not casuals have been under covert or overt pressure to actually underclaim through their timesheets when they make a claim, because they're told, well, you can't claim for that amount. It's unacceptable. I'll only pay you for 8 tutorials instead of 8 times the 3 hours, or however the system works. To what extent is your audit actually drilling down into that phenomenon as opposed to just analysing the timesheets which have been provided?
Well,
provide some information. So in regards to the tutorials and the lectures, we can clearly see if someone hasn't claimed a first lecture before they're claiming for a second. So a second is paid at a reduced rate. And part of this audit was absolutely to audit if within the previous 7 days, the person had not claimed that first lecture, then they would be, their marking and their rate for that tutorial or lecture payment was increased, because that should have been a first lecture, not a second lecture. In terms of, I think one of the other areas is that other academic activity, and that is very, very difficult to ascertain without individuals coming forward to say, you know, I was told to come to a lecture. We are starting to do some of those deep dives in to see if we can find any correspondence like that, doing that without actually sort of behind the scenes if we can, to try and ascertain that so that people don't have to come forward, that we can do that through our managers and through our system. So we are looking at those things to make sure they don't happen, but we also want to tackle it from that culture perspective, that managers can have those conversations with their staff and it comes out with the right outcome, which is you get paid for the work that you perform. And Professor
ultimately, Vice Chancellor, the buck stops with you, doesn't it?
Yes.
When you're the Vice Chancellor, you're the prime leader in terms of this organisation, and it's your responsibility to set the culture across this whole organisation, so you don't get people submitting to a Senate inquiry such as this, being broadcast all over the country, where someone says, constantly being asked to claim less than what I was paid. In a strange way, I was relieved to be unemployed. I mean, it's horrendous, isn't it? That you've got staff making those sorts of submissions to a Senate inquiry.
Well, I don't know if that was a La Trobe staff member, but if it was, then it's absolutely unacceptable. And I accept what you say.
The La Trobe Casuals Network, that's in there. Have you read their submission?
Yes, I have.
Okay, well, if you go back, you'll see that. And another one, a subject coordinator, but designing a piece of assessment, which required this person to mark 120 papers each week over 10 weeks of tutorials. And the expectation was they would mark 1,200 papers over the semester for free, which is just absurd.
Yeah, no, that's unacceptable, Senator. I completely agree.
So how do you change, how do you recalibrate the culture in an organisation? I do sympathise. It's a huge organisation. You've got different schools, different cultures probably within different schools. How do you recalibrate the culture to start to shift those sort of paradigms and those sorts of thought processes that are leading to such negative feedback?
Just before you answer that, Professor Jewett, could I ask Senator Scarr if that could please be your last question, just because of time?
It will be. That's my last question, Chair. Thank you.
Thank you, Senator Scarr. And just note that Senator Faruqi then has a minor matter of clarification that she wants to ask as well. Thanks, Professor.
Thank you. So we're implementing all of the recommendations of the audit, which include clearer guidance to our academic managers about how they should apply different payment rates to different staff. We will check that those guidelines are being adhered to, and we will improve training for both the academic staff who have to administer this system, and make sure that the casuals know what they're entitled to. And as we referred to before, create this third-party route for casuals to query payments where they think they're inaccurate. We think a combination of those things, coupled with improved systems that will make it harder for either party to enter inaccurate information leading to underpayment, that those things collectively will start to shift the culture.
Okay, thank you. Thanks, Chair.
Senator Faruqi.
Thanks, Chair. And it seems like a very clear pathway to me to, circumvent these issues, which is to provide secure employment for your staff. I just wanted to clarify something. When you were talking about payments, your first payment will be to cover 6 years and comes to 3.5 million, from what I understand. And you've now said an additional payment of around 2.5 million will be paid, and that will capture the last 6 months as well as some. Yep. Is that true?
And underpayments for marking. So there are two elements to the.
So 2.5 million, which is further amounts owed for marking, a detailed assessment of which is being currently undertaken.
Correct.
So is that marking? It seems to me like quite substantial. What period does that relate to? And is that over and above the 2.5 million?
The marking assessment relates to the same 6-year period, and the estimated underpayment is included in that $2.5 million figure.
So for the marking as well?
Yes, yeah. So we don't know exactly what the figure is yet because the audit has yet to be complete. But our estimate at the moment is that we need to make a provision for about 2.5 million.
Okay. Could you provide us the final figure once the audit is complete?
We could indeed, yeah.
Thank you.
Thanks, Senators. Thank you very much, Professor Jewett and Ms. Sterry, for your evidence to us today. Your time is appreciated, and we invite you to disconnect from the conference now with our thanks. Thank you. And I now welcome representatives from Monash University. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. To assist Hansard with the recording of this hearing, witnesses should speak clearly into the microphones, and please ensure your microphone is set to mute when you are not speaking. I would also like to advise witnesses that answers to any questions or notice should be sent to Secretariat by 5:30 Wednesday, 9 March. If you have a brief opening statement to make, I invite you to do so. For the Hansard record, could you please state your name and the capacity in which you appear?
Thank you, Senator Walsh. Professor Margaret Gardner, President and Vice-Chancellor of Monash University. Let me thank the committee for the invitation to appear. Let me acknowledge that I am speaking to you along with my colleagues from the unceded lands of the people of the Wurundjeri Nation and the Wurundjeri people of the Kulin Nations, and let me pay my respects to their elders past and present and other elders of lands on which other people in this call may be engaged. The university is committed to ensuring our staff are paid correctly for the work they've done. That's why we initiated a university-wide review of casual academic payments when we were alerted by a complaint that came through one faculty, and that brought the issue of underpayment to our attention. In speaking with you today, I just want to address that review and some related matters. Let me acknowledge that we have previously provided a written submission to the committee on the 18th of September, in which we looked at Monash's approach to compliance with payment matters, particularly in relation to casual staff. When that submission was provided to the committee, we were considering this review. It was in the very early stages. I'd like to take this opportunity. In hindsight, I feel we should have signalled to the committee at that point our intention to undertake this review, and I unreservedly apologise, and we will obviously speak of the outcomes of that review today. The university has a number of systems and processes to audit payroll, so we have annual payroll audits and a series of other processes to ensure pay accuracy. The anomaly that was identified in that one faculty was the basis on which we initiated a whole of university review. It focused on payments to academic sessional staff, and it covered all our faculties and a 6.5-year period from the 1st of January 2014 to the 30th of June 2020. The review was substantially completed and the outcomes communicated to all staff, including in a letter to the head of the union and to the governing bodies in September 2021. There were two main issues identified in that particular review: incorrect timesheet entries by various staff members in relation to work they completed, and the second, inconsistent description of the same academic activity across different sources of information. So, for example, something might be called a laboratory in a timetable and then be called a tutorial in a unit or subject guide. The anomalies resulted in underpayments as well as some overpayments, but the university took a decision to address only underpayments, and all overpayments identified in the review were not recovered. We committed to immediate remediation. It amounted to about 8.77 million in additional salary, and on top of that, interest and superannuation to affected staff. I'm happy to talk about the reasons. We went beyond the remediation of those underpayments, which the majority of which were completed by November 2021. There are still some being finalised and others, of course, pursuing former staff. Beyond rectifying underpayments, the university implemented a number of measures to strengthen its overall approach so that we could minimise incorrect payments in future and ensure ongoing compliance. They included new dedicated human resource positions to undertake additional quality assurance checks on payments to casuals, implementing of a whole new sessional staff scheduling system, and significant further training and support for all staff who are making claims, both those casuals who are making claims and those who are assessing claims in relation to sessional payments. We've also undertaken to commission an independent post-implementation review of the new timesheet and scheduling processes, which will be overseen by the Audit and Risk Committee of the University Council. I just want to say a couple of other things. I mean, I have apologised and I reiterate my apology unreservedly to all the staff and to the NTU as representative of them, and that apology was issued on the 23rd of September 2021. We provided that all staff, the details of the remediation actions being undertaken, comprehensive questions and answers. We established a dedicated phone and email address for staff queries pertaining to the review so they could lodge claims, maybe other claims, or they could ask questions. We published a statement on our website. We have also committed, and I've written to all staff about this, to introduce and agree to provisions for increased job security. There are a series of measures which I won't go into here, given the time, in our enterprise agreement, but I'd point to two in particular. We have a form of periodic academic employment in our enterprise agreement to allow staff who'd otherwise be engaged casually to be on a specific engagement. It's a Monash-specific provision. And we have a category talking about fixed-term staff, which we're not principally talking about here, to take them on to continuing contingent employment rather than contract employment. In 2021, we took 324 fixed-term staff to continuing employment. We took 125 staff from casual to continuing employment. We took 580 staff from casual employment to fixed-term employment. In total, in those 2 years, we took 1,029 staff to more secure forms of employment. I made it clear to staff in my communications to them that we were trying to reduce the number of people on fixed-term contracts, and if they were on fixed-term contracts, to make those longer rather than shorter where that was possible, and that we would attempt to get casual staff, reduce the overall amount of casualisation. To that end, we proposed to the union, the National Tertiary Education Union, a proposal to provide more secure employment to Monash PhD students who are undertaking casual employment. We've negotiated that. It has not been concluded as yet, but it would result in employing those students for a 4-year period of their PhD study rather than on casual engagements. And with that, I realise I've probably taken quite enough time and I'm galloping through this, but let me conclude by reiterating Monash's commitment to ensuring all staff are paid accurately and in a fully compliant manner, to attempt to, as much as we can, reduce the insecurity of employment, both for fixed term and casual staff, and to put in place proposals to deliver that and to improve support for staff, not just in greater employment security and ensure that all employment conditions are fair and equitable, but to ensure they are completely aware of all the mechanisms that are available to them to raise complaints and grievances either individually or collectively. Thank you.
Thank you, Professor. Senator Faruqi.
Thank you, Chair. Good afternoon. So, Professor, as you just alluded to in your submission to this inquiry from 18 September 2020, it said that Monash has not engaged in wage theft, but we do know that underpayments have been admitted to the tune of, I think you said $8.77 million?
Yes, in salary, then including interest and superannuation. Yes.
Yeah. How many people were impacted by these underpayments?
There were 2,227.
And this is all
staff.
current staff? Or previous?
No. Some of them were current and some of them were past staff. Out of a total cohort of 12,538 staff.
538 staff. And how many? And these were all casual employees?
Yes.
And have all of them been paid back?
The great majority of them have been repaid. We are still, with former staff, tracking through bank details and attempting to contact them. So not all of them have been paid, but we have paid the overwhelming majority of them by the end of last year.
What do you mean when you say an overwhelming majority? Because we heard just earlier today that 4,000 out of 11,000 was a minority. So I just want to make clear, what is an overwhelming majority?
80% of current staff were paid by November 2021.
65% former staff.
And please, and my colleague, who's the Chief Human Resources Officer, Phil Vaughan, can talk about the rest.
Okay, thank you. So, thank you, Senator. So, as the Vice-Chancellor said, we've remediated 80% of current staff. We are working through some final validation issues in one faculty, which we hope to do in the next 2 months. and to resolve those concerns. We have remediated 65% of former staff, and we're doing that by carefully working through the guidelines of the Fair Work Ombudsman. They've got specific guidelines about how we engage with former staff, and that does take some time, and we hope to have that completed by the middle of this year.
So as of today, how many claims of underpayment are underway at Monash?
So we do...
You might need to take your mask off.
Sorry, yeah. I'll take my mask off.
Sorry, it's Mr. Vaughan, is it?
It is.
Yes, thank you. I was just checking on that for Hansard. Thank you. Please continue.
Thank you. So in terms of the review that we undertook, we are addressing all the issues of underpayment that were identified. We are a large organisation with a great degree of complexity, and we do, as any organisation would, as we're implementing the system changes that we have identified a few other issues, but we have not identified anything on the scale of what we're discussing here today, and those issues are being properly logged and resolved in accordance with our processes. So, as the Vice-Chancellor indicated, we do have a dedicated email and phone line if people have concerns that they wish to raise, and we carefully go through those concerns as they're raised.
And that audit that you conducted, is that across all faculties and across all staff?
Yes, Senator Faruqi, it's Professor Gardner. Yes, it is across all faculties and across all academic sessional staff, yes.
And Professor Gardner, you did directly address this question of casualisation in your opening remarks, and I do thank you for that. Do you see casualisation as inextricably linked with wage theft? And I'm conscious that not all universities have made that connection here today.
So first, there are categories of casual employment, and leave aside, I've just spoken to you about a proposal to provide slightly more secure employment for PhD students, which is yet to be resolved with the union. There are categories of casual employment that I anticipate will continue. If you look at the categories of staff that we employ casually, about a third of them are PhD students. I have urged on the union the proposal we have, which would give them a contract for the time of their PhD, but there are all sorts of issues with PhD students. We have 5,000 PhD students, and it is part of our responsibility that we provide them with the sort of experiences that are necessary to advance their career. The second group, we are a large university, comprehensive, teaching a large number of professions. We bring in a third of the casual academic workforce, lawyers, doctors, business people, bringing their professional expertise employed elsewhere, bringing their professional expertise to education to enrich the educational experience. So I do not anticipate that those categories should disappear. The third category are people who may be seeking, may not be, but may be seeking other academic employment and are neither PhDs or not full-time employed, or not wishing, people who are not wishing for employment with the university. And that area I think we do need to reduce, because they are seeking a more secure form of employment, and it's important that we have the appropriate level of staff to undertake that. Now, your question was, does this lead to underpayment? The systems are incredibly complex in terms of payment, as you know. They date back to the Enterprise Agreement of 2010. They weren't the award of 2010. They haven't really been significantly changed. They are complex. I could wish that they were otherwise, but that is the situation we are in. That doesn't help. There is also significant need to talk about the different circumstances that pertain in different areas. We have centralised in this systemic review a number of things with the sessional timetabling. So yes, the typical way it was done with decentralisation, the range of people with different expectations, that complexity led to a situation where there's more likely to be uneven ways of dealing with this, and it is trying to get a clear, more systematic, more secure employment will indeed improve this situation, and that's actually what we're trying to do.
So in terms of improving systematically insecure employment, has your university set any targets for conversions and targets for secure work for the future? Or are you looking at...
We haven't yet set targets, because what we attempted to do was to move on two fronts I've talked to you about. One proposal in terms of casual staff, which between you and I had hoped would have been resolved before this, but hasn't been. They take time. And implementing around policy we have in relation to fixed term staff. And what we were attempting to do was to, with that, actually make a significant reduction on which we could then look at what was, as I say, there will be some casual staff we will need to keep. What is the scale of that is actually needed to do the two things I said, PhDs in particular and professional expertise from other fields. But we haven't set targets yet. We need to get those other things resolved and in place, in my view.
And you've talked about the complexity of the systems and, that you're trying to fix those. Do you think a regular independent government audit of how of those systems or, payments to casual staff at universities, is there a compelling argument to have something like that? So these sorts of things never happen again?
I need to be clear about the scale of the review we did with a quality assurance partner and an audit partner. It involved 1.8 million timesheets. It involved over 250,000 manually examined pages of material in order to try and determine that description of activities. That's not something, we do regular payroll audits every year. We identify areas that we think are at risk. So we do those. We report to, obviously, in our case, the Victorian Auditor General. We are, in this case, engaged with the Fair Work Ombudsman. In our state, there is another authority. There are a significant number of authorities who engage with us and to whom we report and talk about these things. I think there are significant channels industrially and in regulatory terms to actually work through this issue. And I just want to emphasise that when we looked and could identify what we thought was happening, the particular anomalies in our case, we moved into what was a very significant piece of work involving huge numbers of staff to actually manually go through this process. I think what you see in that is good faith. It's the good faith of people trying to be good employers.
And just my last question, which is something which is really worrying me, and there are lots of things to be worried about here, is casual staff telling us again and again, and some of them actually appeared anonymously today because they were fearful of the repercussions of speaking out. And they have, they've used terms like, once they spoke out, they were told marked man, or, they would lose their casual position. I just wonder if that concerns you, and have you actually investigated this at your university, and what are you doing to rectify it?
It would concern me if any person in a position of authority over someone else in the university was effectively engaging in what you might call bullying or coercive behaviour, and there are certainly very serious procedures to deal with that discipline. The reason we have the dedicated line is so people can raise their cases and make their concerns known without having to go directly to their employer, their direct supervisor, if that is the case. I think that the university should be aware as much as we can culturally by speaking from the council, from the senior management, that we are seriously concerned about attempting to actually provide high quality, secure employment to the best of our ability, and that we've demonstrated that in many ways. That sort of behaviour would be unacceptable. I think they should feel free to bring complaints.
Well, they don't. How many people have reported through that dedicated line that you have?
I'm going to have to look to my colleague,
if
Mr.
you
Vaughan.
don't have it now, could you take it on notice? Because people are full, and it's not just about line managers. There's a whole culture. So this is the thing I've been hearing from universities over and over. You know, it's the line managers who are to blame for whatever the reason for all of this is. And then, you know, at the governance level, people with the big pay packets are just kind of, I think, you know, are kind of abrogating their responsibility. Shouldn't it be the case that, you know, the responsibility should not be shifted, and that people who run and govern the place should be made responsible?
We are responsible, and we do take action. We have to take action appropriately on what we find. For example, we try to find out, you know, you sort of take the temperature. You try to make it clear that people can make complaints. People do make complaints. You could wish to get rid of all bad behaviour. Sometimes people behave in ways that are unacceptable, and appropriate action is taken. But we do take responsibility, and that's why you make the statements and stand behind the sort of policies and processes that we do in order to allow people to be represented, to make the complaints they need to make, and to understand that that is an acceptable thing to do, to raise the issue.
Okay. Thank you, Chair. I know that other people might have questions as well.
Thank you very much, Chair. You Thank you. Thank you, Chair. Professor Gardner, thank you for appearing today. I'm about the hearing this afternoon. Can you hear me, Professor Gardner?
Senator Van, you're just breaking up a bit.
I've got a right in front of me. Is that how better? Wait a second. Do you want me to send on the scale? I'll fix my audio.
Chair, I'm happy to ask a few questions while Senator Van fixes his microphone, if you're happy with that. Okay. Professor Gardner, can I first congratulate you on apologising? Can I sincerely congratulate you for doing that and for owning the issue, because I think that is an incredibly important thing to do. And we've heard from a number of institutions earlier today, and I was so pleased to hear a leader of the university, the position you hold, to acknowledge wrong, to apologise, and then we look to move on. So I found that I'm glad you're the last witness for today. It's ended on a positive note.
Thank you, Senator.
Okay.
Thank you, Senator.
So can I ask you this question about culture? So from my perspective, culture has a lot to do with it. You've got the systems, you've got the processes, you've got payroll doing what it wants to do, but we've heard from a number of casuals who talk about the covert or overt pressures on them to underclaim, right? That whatever the pressure being applied, maybe by their line managers or whatever, it's applying pressure on them. Well, you can't really claim for that. Even maybe you can under the enterprise agreement, but we don't want you to classify your work in a different way, so we pay less. So these sorts of pressures on the casuals. So do you recognise that this isn't just about systems and processes? It's all about culture in terms of valuing the work that everyone performs, whether or not they're a full-time employee, part-time or a casual employee. Do you recognise the importance of culture in that regard?
I do recognise the importance of culture. I will say that I think there are a series of things that I've indicated we're doing, both in policy, well, hopefully in policy proposals and in systems, that will make errors which are either inadvertent or perhaps of the other sort less likely to happen. Because the scheduling system will pre-populate, it will actually mean that someone's interpretation about what you can't do, it will be seen and overseen at a higher level, so it's not so decentralised. So yes, systems are important, but I'd agree with you that culture is important. And one of the reasons for doing the review and opening the review and opening the dedicated line and writing, I can't guarantee that all staff read my all staff emails, but writing out and saying, it's very important that we have this proposal, that we have people in more secure employment, not less. It's all about signalling and culture and making people feel that they can raise the issue. And so, yes, I agree with you that it's important about culture. It's important that culture is right, because however people might think it should be, whether it's based on past experience or current experience, you've got to keep signalling that there is the opportunity to raise the issue and to know that it will be listened to and actually actioned, and that you will be treated fairly and equitably.
But it's also, my last question before we go to Senator Van Chair, but it's also not just about people raising the issue. It's about people who are in positions of responsibility, wherever they are in the system, who proactively identify issues. And if someone puts in an incorrect timesheet, the culture is such that they want to make sure that the casual for whom they have managerial responsibility is paid everything they're due. So you don't sit there and wait for someone to make the claim. You actually proactively make sure people are paid every single cent that they're entitled to. Do you agree with that proposition?
Yes, and that's why we've put in extra dedicated HR resources that are actually doing more quality assurance, so that we can make sure that if there is an error, it won't slip through the system. So we've got multiple layers. So we actually have hired more staff to do that.
Okay. Thank you, Professor Gardner.
Thank you.
I'm hoping I can now be heard.
You can. Can you hear me?
Excellent. Okay, over to you, Senator Van.
Can you hear me now?
Yeah.
Wonderful. Professor Gardner, thank you for appearing today. I know we're running out of time, so I'll try and be quick. From the sessions this afternoon that I've followed, the committee has been particularly focused on sessional and casual staff. I think it's critical that when you're looking at aspects relating to sessional and casual staff, that we're not losing sight of the raison d'etre for universities, which is research and education. Given that Monash is such a big contributor to the Australian university system, I'm sure this is probably the case for Monash. Are there unique aspects to the Australian university system that shows that casual and sessional workers add to both the experience of the student and of the casual staff? You mentioned earlier PhD students as a particular example who don't have the opportunity to work full time and do their studies or research. Could you talk to that?
Yes, that's why I, in an earlier answer, indicated that there are some aspects of casual employment, though, as I said, we have a proposal with the NTU that would even make the PhD student employment more secure, but it has to get to adopted and into the enterprise agreement. The point about PhD students, and indeed I can declare, indeed I was a casual, a sessional employee when I was doing my PhD, so it has a long history, as you might gather, and they cannot only work for a certain amount of time. It's a really important part of embedding them in the university operation. And the thing that's really important to me is that we do that appropriately with the appropriate form of support and staff development. It should not feel that they're engaged in teaching in a burdensome way. It should be something that is a real enhancement of their overall experience through their PhD. Similarly, because Australian universities teach so many professions at undergraduate level, which is not true, for example, in the United States or some other areas. So a huge number of lawyers, doctors, etc. at undergraduate level, we're talking relatively large operations in which you're trying to bring those professions in to give people that connection to the world they're going to go into. I think that's really valuable to their educational experience. Again, has to be properly curated and managed, and those people have to be treated appropriately. There is another reason why, and I'm here not speaking against trying to have controlled appropriate experiences for where there are casuals employed, but Australia's unusual compared to some countries. So we respond to student demand. So if lots of students suddenly decide to do data science or forensic science and move themselves out of chemistry or physics, we expand the classes. So there are some university systems where they'd say there's only so many spots, that's all the spots we've got, that's it. And when those fluctuations happen, often there's a need for some initial casual staff. You should, if it becomes, clear that that's going to continue, hire then more permanent staff. But that makes Australia different. We flex with student demand. I think personally that that's a good thing. We're a very flexible system, but it does have this inherent danger of flexing up and down the casual workforce. So we have to have really good systems to maintain and deal with that so people don't get underpaid or feel that they're as a, not as a valued workforce, because these are valued employees, they're valued part of our educational and research and other experiences.
One last question. And did the last 2 years of COVID put more pressures on your staff that sessional or casual staff helped fill? And I'll declare that as a postgrad student over that time, having staff that could step in and assist was, my lived experience was that it added greatly to my learning experience.
Well, I can tell you what happened to the headcount at Monash. So we increased our casual and sessional headcount from 1,578 to 1,714 from 2020 to 2021. And that was deliberately to do these things. They supported the move to hybrid education by helping with course design because everybody was flipping their classrooms. And we provided a lot more academic support to domestic, and particularly any domestic or international student who, was some distance away. We had a requirement to have COVID marshals, which we hadn't had before, and we put a whole lot of extra security and event staff at the various times that we reactivated the campus. So we increased the headcount. We actually didn't increase the amount in full-time equivalent of sessional employment, but we just ended up hiring a whole set of different categories. The proportion at Monash of full-time equivalent sessional staff has been about 17% of the total academic effort, and it's been like that for the last 5 years. Fluctuates a bit up and down, but about over 70% of our sessional staff work 0.2 of a full-time load or less. So That's what I mean. It's a big workforce, it's a complex workforce. It's very important that we get better at the systems that prevent the sorts of things we've identified in our review.
Thank you, Professor, and thank you, Chair.
Thank you, Senator. Thank you very much, Professor Gardner and your colleagues, for appearing as witnesses for us today. We appreciate your evidence and your time. It will very much assist with our deliberations, and we invite you to disconnect with our great thanks. Thanks very much.
Thank
you, Senators. Thank you, Senators.
Thank you.
Thank you. And that concludes today's public hearing. On behalf of the committee, I would like to thank all those who have made submissions and for the witnesses making themselves available and their ongoing cooperation in this inquiry. And the committee stands adjourned.
Thanks
everyone.
And thanks, Senator Scarr in particular.